now, despite the Deputy CEO or CEO's decisions being an exercise of public power, performance of a public function, there is no court that can second guess or look into that question, for the reasons, again, like I say, that we will submit that is simply untenable. We say that the starting point in answering the question of jurisdiction is, in fact, the Constitution, and that power is set out in Section 166E, which sets out what the courts are of the Republic. And what Section 166E says is that the courts are the Constitutional Court, the Supreme Court of Appeal, the High Court, and any court of appeal that may be established by an Act of Parliament, and particularly of importance to this case, any other court established or recognized in terms of an Act of Parliament, including any court of similar status either to the High Court or to the Magistrate Court. What this means, and there are authorities that I will take the court through that actually demonstrate that on a proper reading of 166, this is a court referred to in Section 166E of the Constitution. This status is set out in three legislations that actually govern the ruling of the court. The first is the Electoral Commissions Act, the second is the Electoral Act, and more importantly, the Constitution. And so the first point we make is that this is a court in terms of 166E of the Constitution, and that opens up all sorts of avenues that we will demonstrate about how this court can in fact exercise jurisdiction on the application before it. Which brings us to then the second point, which is what has this court said about its own jurisdiction? We rely on the decision of this court in African Christian Democratic Party, ACDP, their 2004 decision that's cited by the Commission in its papers. And the first point we make about ACDP is that the version that's been put by the Commission in its papers is that this court in ACDP said it does not have the power to look anything beyond the Commission's own decisions, and that it is in fact not a superior court. However, the difficulty with that particular argument is that when the Commission in fact does that, it cites the judgment partially. In fact, when one considers paragraph 12 of that particular judgment, what the court is doing, which is what's cited by the Commission in its papers, is restating the argument by Azapo, not making its own pronouncements. In fact, in paragraph 12, which is the part that's in fact cut off from the Commission's heads, is the court writes, Azapo's standpoint, as I understand it, is that this court is not a court of first instance. It can only deal with matters referred to it on appeal or review. This court therefore has no jurisdiction to deal with a matter which the Commission refused to deal with. If the matter were left open-ended, and that was precisely what Section 25(3) seeks to avoid, an absurd situation could arise. The Electoral Court cannot deal with matters not dealt with by the Commission. The Electoral Court is a creature of statute. It derives its jurisdiction from statute creating it, and unlike the Supreme Court, it has no inherent jurisdiction. That's what the court says is Azapo's argument about this court's jurisdiction. And then here's what the court says towards the end. It says that the review application in the Jamie case, which is the case relied on by Azapo, was brought before a tribunal, not a court. The issue before the appeal tribunal, though in part relevant to this matter, was only related to the leading of oral evidence on a matter not dealt with by the Chief Director. Whilst the judgment is persuasive, it is not binding on this court, and as Mr. Mokotodi would have the court accept. Mr. Mokotodi did not, it appears, give sufficient considerations to the provisions of Section 20 of the Commissions Act and other related provisions. Then the court goes on to quote what Section 20 in fact says. And then it says, in short, the power of this court in electoral matters are wide-ranging. Section 18 of the Commissions Act explicitly accords it the status of the Supreme Court, and now the High Court, it says. While there may be merit in the argument that it does not enjoy those inherent powers that the High Court has, it has certainly, in my view, enjoyed extensive powers in relation to electoral matters. It is the final court of appeal or review in all such matters, and it says, see Section 96 of the Electoral Act. Mr. Mokotodi rightly and very correctly conceded that his jurisdiction point had no merit and accordingly withdrew it. And then the court says in paragraph 14, part of the problem in this matter is that neither party appears to have considered the effect of Section 20 of the Commissions Act. The applicant pleaded its case based purely on Section 55, claiming relief it would appear under Section 56, contending for a serious irregularity having occurred relating to any aspect of the election. And then in paragraph 15, which is of quite importance, I am unable to agree with the view that the court, in light of the very wide powers it has in electoral matters, cannot, on application, as it is in the case here, correct declared results arising from some underlying administrative error in appropriate circumstances. It would seem to me that by failing to do so, the court would not only be acting irresponsibly, but would be abdicating its constitutional imperative to ensure free and fair elections. It must follow, therefore, that even if there is merit in the second respondent's argument, being Azapo, that the Commission was functus officio in dealing with this objection, this court is nevertheless at large in appropriate circumstances to deal with the matter in terms of its review powers contained in Section 20 of the Commissions Act. So the simple point we make is that the argument that's been advanced by the Commission about why this court does not have jurisdiction was squarely rejected in the very same judgment they in fact rely on. Which then brings me to the second point about, or the third point rather, about how the Constitutional Court has dealt with the jurisdiction of this court. In that respect, we rely on the decision of the Constitutional Court in Calm versus Independent Electoral Commission. In particular, we rely on paragraphs 40 and 41 of that judgment. And there, Justice Wallace, writing for a majority Constitutional Court, writes, "Is there anything in the context that would warrant a more restrictive interpretation of the section and hence of the Electoral Court's jurisdiction? I think not. The clear purpose was to establish a court that would deal with all matters in relation to electoral matters. It was constituted with the same status as the High Court and with a judge of the Supreme Court of Appeal as its chairperson. It is to resolve electoral disputes as a matter of urgency. There is not the slightest indication that the intention was to limit the range of disputes that would fall within the ambit of the Electoral Court's jurisdiction, so that some electoral matters would fall within its jurisdiction and others would not. Instead, the breadth of the language used suggests that the statutory purpose was to create a specialist court that would deal with all electoral matters. And our jurisprudence holds that when a specialist court is created, the apparent purpose of creating a single forum for resolving disputes of a particular type is not to be stifled by a resort to undue literalism and too careful a parsing of statutory language." Then in paragraph 41 it says, "This construction is strengthened by considering what is empowered by a court of review in this context. In ordinary language, it is a power to reconsider and, if necessary, replace the decision of the IEC. It is not a narrow appeal power bound to a record where the court decides merely whether on the record the decision was right or wrong. Nor is it even a narrow review power where the process through which the decision was taken is scrutinized, but the merits of the decision are not considered. Instead, it is the widest possible type of review where the decision in question is subject to reconsideration, if necessary, on new or additional facts, and the body exercising review power is free to substitute its own decision for the decision under review. And then it says at the end, on the face of it, the jurisdiction of the Electoral Court to deal with such matters, such as an irregularity, must arise under Section 21 of the Commissions Act. It could not effectively exercise that jurisdiction unless a review power under that section is described as above." So then, what then does that mean? And this is then the fourth point that we make about jurisdiction. Here, we say that the finding in Calm that this court has the widest possible power in review and is not bound in the ordinary sense as you would consider a review application is consistent with what the court has held in relation to other forums. The one judgment is the judgment of Ledla in the Constitutional Court, where the Constitutional Court said whilst a special tribunal was not a court, it had the power to consider legality reviews given its statutory status and powers. There, the court held that legality reviews fall within the remit of the tribunal's powers as a necessary condition to the fulfillment of its statutory duties. Put differently, how else can the court ensure compliance with the statute that it's specifically been given power to review in the absence of being able to deal with review challenges? And then in Group 5, again, a similar challenge where the Competition Tribunal's jurisdiction was challenged. And the question before the Constitutional Court in that application is, can the High Court exercise concurrent jurisdiction with the Competition Appeal Court in deciding the ultra vires 1 and legality reviews 2? And again, a majority of the Constitutional Court said absolutely yes. And the reason it said so in Group 5, and we find that in paragraph 125 of that judgment, is that when you look at, and we started off with the Constitution, it says that the courts of the Republic are the following, and it sets it out in 166E. And then importantly, in 172(1) of the Constitution, it says a court has the authority and the power to declare any law or conduct that is inconsistent with the Constitution as such. Then the question becomes whether this is a court as defined in section 172 of the Constitution. And we say, for very clear reasons, both in ACDP and in other judgments by this court, that it is in fact a court, and it does have the power under 172(1) of the Constitution to declare any law or conduct that is in fact inconsistent with the Constitution as such. Which leads us to our fifth and penultimate point, which is, this is the argument we've heard a lot from the Commission. Is this a matter that could have in fact been served before the full Commission? In other words, are the alter vires challenges that we raise here and the legality review we raise grounds upon which the Electoral Commission could have in fact entertained? And we say no. And we say so for three reasons. The first is that the court would have to consider the structure of section 15 and 16 of the Electoral Commissions Act. In particular, section 16(1), which sets out the grounds upon which a aggrieved party can appeal to the full commission. And it sets out three grounds. The first ground is if the 14-day requirement for publication has not in fact passed before the commission renders a decision. The second is if the logo, the name, or the abbreviated name of the party would lead to voter confusion. And the third would be if the name of the party is ostensibly racist or sexist or any of the listed grounds set out in section 16. The point we make is the only way that the Commission can deal with an appeal is if the grounds which a aggrieved party sets out are in any of those three. The question then becomes, what if a party wants to raise an alter vires challenge? What if they want to bring a legality challenge? Where do they go? And we say they come here. And we say they come here because this is a court. It is established in section 166E. It has powers under 172 of the Constitution to declare any law or conduct inconsistent with the Constitution. And as the court knows, that particular power to declare law or conduct stems from section 1C of the Constitution, which enshrines the rule of law. That's where courts get their legality power. That's where courts can test alter vires challenges and whether decisions made by a party in fact are lawful or not. The second is the difficulty with this argument from the Commission is that it demonstrates an absurdity. And what we mean by that is that it presupposes that the Commission had the power to entertain such a challenge. And as I've argued, the Commission can only deal with challenges on any of the three grounds set out in section 16. Anything outside of that, it simply has no power to entertain. But the second argument to that is that argument is only good if there was publication the second time around, which is the argument you'll hear about later. And that's because section 16 demonstrates that the trigger for the right to object and appeal is publication. But in the absence of publication, no party can go to the Commission and lodge an appeal. And as we know from these facts, there was in fact no publication the second time around. So it can't fall in the mouth of the Commission to say you should have objected when there was in fact no publication the second time around in circumstances where it has rejected an application and invites a party to lodge a fresh application. Then there's an argument made in the heads of argument that we raise a new point in reply, which simply has to be rejected. And the point simply is that by relying on the Commission's other powers, the Electoral Act, the Constitution, we make out a new case. But that can't simply hold, because jurisdiction is not a question of fact, jurisdiction is a question of law. And what the court does is it looks at the pleadings as pleaded, and it asks itself, on the pleaded facts, do I have jurisdiction? If we were to take the argument of the Commission to its logical conclusion, it means that where a party has not stated that the court has 172 powers, the court is simply deprived of exercising those powers. That simply cannot be, because the affidavits don't establish the law, they establish the facts. Then the last point we make about jurisdiction is section 1691A2 of the Constitution. And what we say about this provision is that 169(1)(2) of the Constitution asks the jurisdiction of the High Court. Put differently, that the High Court doesn't have the power to entertain the kind of matter that's before the court today. This is because Section 169(1)(2) makes plain that the High Court does not have jurisdiction over constitutional matters that fall within the statutorily prescribed powers of a specialized court. In other words, you cannot go to the High Court and complain about an alter vires challenge or legality challenge in electoral matters because this court in fact exists. That's what 169(1)(2)(a) actually says. And as the court knows, challenges to alter vires, challenges to legality are in fact constitutional matters, and there's ample authority in support of that particular proposition. So what we say on the last point is that taking 169(2)(1)(a) into account, it would appear that review applications that are within the realm of electoral laws fall within the jurisdictional bounds of specialized courts, such as this particular court. I then move on to my last submission dealing with delay, and I'll speak briefly about those submissions. I'm mindful of the time. The first question is, are we actually late? And we say that we are not. But to the extent that we are in fact are late, we ask for condonation and we say there's a strong case made out in the papers why condonation should be granted. The starting point in that argument is that in the Constitutional Court in Buffalo City Municipality versus Asla Construction, at paragraph 49, the Constitutional Court says the proverbial clock starts running from the date that the applicant became aware or reasonably ought to have become aware of the decision in fact taken. And we say that on the facts, at worst for the ANC, the 24th of November, when its appeal was refused by the Electoral Commission, is the date on which you must start that clock. And at best for the ANC, that clock starts on the 7th of January when it learns the reasons for the rejection. And that's where the alter vires and the legality challenges became apparent. But even if you were to calculate either from the 24th of November or from the 7th, we say on the 7th of January, we were here in court on the 10th of January, that falls within the 3-day requirement. But if the court says at worst the 24th of November, that's still 29 court days. We've seen in the Electoral Commission's papers that they use calendar days obviously to demonstrate an exaggerated amount of delay. But 29 court days is how late the ANC in fact was. And the question becomes, and this is the second point we make about delay, whether those 29 court days, if we are in fact incorrect on the 7th of January as the start of the clock, the question becomes whether that 29 court days is unreasonable. That's the starting point. And this court very recently in January of this year, in Electoral Commission versus Umhlatuze, said that the starting point with legality reviews is not the same as 180 days in Paja. The test is whether did you come to court within a reasonable amount of time. Now we know of the 3-day requirement in Rule 6.1 of the court's rules. But the difficulty with the arguments made by the respondent is that it stops short of simply saying you were late by 3 days and no more, therefore that's unreasonable. That can't be the measure. Because as Mhlatuze says, the measure is you look at firstly whether the delay is in fact unreasonable. And how you in fact do that is the court says, firstly, this court says in Mhlatuze paragraphs 11 and 12, that where the delay can be explained and justified, then it is in fact reasonable and the merits of the review can be considered. But where there is no explanation, this invariably means that in fact the delay is in fact unreasonable. But what this court says about the first test of that, because it's a two-pronged test, is that it involves a factual analysis that requires the court to make a value judgment, having regard to all the circumstances in the case. In other words, what the court says is where the interests of justice require overlooking the delay, then the court must in fact do so. So what we say about this is, number one, we say we weren't late if you start counting from the 7th of January. But if we were, 29 court days is not unreasonable in the circumstances of this particular case. The ANC sets out what the reasons are for its delay and the fact that this application was lodged in December of last year. And if the court then finds, if the court thinks that the delay was in fact reasonable, that's the end of the inquiry. However, if the court is of the view that the delay was unreasonable, then there's a second test, or the leg of that inquiry. And that requires, as this court says, a flexible analysis that looks into a legal evaluation, taking into account a number of factors, such as potential prejudice to the affected parties, as well as the possible consequences of setting aside that decision. And we say again on the facts that it simply cannot be that when a party is late by 29 days, court days at worst, that can in fact be said to be unreasonable. Then the third point we make about delay is this. Does delay in fact mean that this court should dismiss the application? And we say no. And we find authority for that again in Buffalo City Metropolitan versus Asla Construction. There, at paragraph 63, the Constitutional Court says in a majority judgment that even where there is no basis to overlook an unreasonable delay, the court may nevertheless be compelled constitutionally to declare the state's conduct unlawful. This is because Section 1721A of the Constitution enjoins the court to declare invalid any law or conduct that finds itself to be inconsistent with the Constitution. So what we say about this particular judgment is that even if the court were to say the ANC was unreasonably delayed in its 29 court days, the buck does not end there, because 172 of the Constitution compels this court to declare any law or conduct to be inconsistent to the extent of that inconstitutionality. And then it adds at paragraph 66, relying on the well-known Gijima judgment of the Constitutional Court about delay, that the court says, Gijima dictates that where the unlawfulness of the impugned conduct is clear and not disputed, then this court must declare it to be unlawful. This is notwithstanding an unreasonable delay in bringing the application for review, for which there is no basis for overlooking the delay. Whether an impugned decision is so clearly and indisputably unlawful will depend on the circumstances of each case. And you'll hear more from my lead about what we say about that. So we say if we make out a case of illegality, which we say we have, the court has no other choice but to declare that conduct to be unconstitutional, despite the delay. And then finally, on the point about delay in Khumalo at paragraph 25, Khumalo versus MEC, the Constitutional Court cautioned against allowing a procedural objection from preventing the court from looking into the challenges of lawfulness in the exercise of public power. There, Justice Guaiya, for the majority of the court, says, in the previous section, it was explained that the rule of law is a founding value of the Constitution and that state functionaries are enjoined to uphold and to protect it by, inter alia, seeking the redress of a department's unlawful decisions. Because of these fundamental commitments, a court should be slow to allow procedural objectives to prevent it from looking into the challenges of lawfulness of the exercise of public power. And we say that's what the court is here to do today, to look into the lawfulness of the exercise of public power by the Deputy CEO of the Commission. And then finally, on this point about delay, the court must ask itself, what are the consequences if it were to turn the ANC away? We say that there are three. The first is, in Calm and several other judgments of the Constitutional Court, and in fact of this court, lawfulness of decision-making is placed at the center of a free and fair election. And we say that if you cast aside the rule of law in this particular application, there is a very serious and material threat to whether the elections that we're about to have on the 29th of May are in fact free or fair. This is because there are questions regarding the legality of a party on that particular ballot and whether that party should in fact be there in the first place. And so we say that's not an issue that the court should turn away from. It's the very thing that this court was established to decide, to protect free and fair elections, to protect the right to franchise, but importantly, to uphold the rule of law. The second point we make is that the closer you get to the elections, the greater the prejudice, not only in fact to MK, but again to the very project of free and fair elections. We say because if you are to in fact do that, as the court is aware, the calculation of seats in the National Assembly is dependent on the votes of each party in relation to one another. So if we are booted out and we're told this court doesn't have jurisdiction or the delay is in fact excessive, what that invariably means for us is that we will have to go to the High Court, despite the fact that we say on 169 of the Constitution, the High Court doesn't in fact have jurisdiction. And if the High Court were to rule in our favor, The invariable position on 172 is, one, it will have to declare that law or conduct to be unconstitutional, and two, it will have to attempt to unscramble the egg after the 29th of May. And we say that is an undesirable position because invariably, if the calculation of seats in Parliament are dependent on how each party performs in relation to one another, if you take out MK from that particular equation, the entire equation would have to actually start afresh. And we say that's an untold consequence the court should in fact try to avoid. And lastly, and perhaps the most importantly of all of these, is the Commission tells you in their answering affidavit, and you'll find that at page 87, paragraph 47.2, that this is how they always do things, that they consider supplemental application whether they meet the requirements or not. And we say that there is absolutely every need for this court to decide on the merits whether the way in which the Commission has exercised its power is the way it should always exercise its power or not, where it considers supplemented application. There is a need to provide the Commission guidance on that aspect, particularly because I think they touch 3 or 4 examples where they've done it with other parties. So if we are correct that the way in which they've been exercising that particular power is unlawful, there's a need to stop that now. Because it's not just about this election, it is about every by-election, every local government election, every municipal election, every provincial election, every national election thereafter, if the way in which the Commission has been exercising its power, which we say is unlawful, continues. So there is every need, we say, on the papers before you to consider the application. We say that the court amply on 5 points that we make has jurisdiction. We say on delay that it's one, we're not late, but to the extent that we are, it is not unreasonable on an assessment of this court's authority. But in any event, even if we are in fact late, it doesn't mean that the application is dismissed. You must still declare the law of conduct unconstitutional because 172 enjoins the court to do so. Milady, those are all my submissions.
Mr. Ramukhali, your client is contending for both urgency and condemnation, and you seem to have argued the 2 points in one stroke when the tests for each is different. So I just want to clarify if you're still persisting with the urgency argument, because you focused on the condemnation leg.
I'll make 2 points about urgency, and I'm mindful of time. The first is that the statute expressly says matters of electoral matters are inherently urgent. And we say the statute already gives an indication to the court how we must in fact deal with this matter. The second is similar, related to the arguments we make about delay, that we came as quickly as we possibly can, and that our delay in fact is not unreasonable if the court finds that there is in fact a delay. But the third point is that this is so important given that the 29th of May is around the corner, that if the court turns a blind eye to that, there is simply no substantial redress available to the ANC because of the unscrambling egg argument I in fact made, that you simply can't turn us away now because the 29th of May is around the corner and there's every need for legal certainty about whether MK is going to be on the ballot lawfully or not. And that's not something that can be kicked past the 29th of May. It has to be decided now. Thank you, judges. Those are my submissions.
Just before you sit, I want to take you back to the issue you argued on the question of whether or not in the replying affidavit there was a new case that you made. Are you saying in your appeal the same ground that you are raising now, that there was no application before the DCE, the DCO or the CEO, are you saying that that argument was raised when you raised your appeal?
No, Judge Shongwe, as I understand the point on the new case made out in reply, it is that we are now seeking reliance on the Electoral Act, when in our papers, in our founding affidavit, we didn't specifically mention the Electoral Act. We say that can't be a new case. It's common cause across all parties that the ANC did not, in its appeal to the Commission, raise the alter vires challenge, raise the legality issues. These are issues being decided for the first time by this court. The argument in the heads of argument is, by relying on the powers of the court in the Electoral Act, we make out a new case on jurisdiction. And we say that's not, in fact, the case.
Thank you, Councillor. On the issue of jurisdiction.
Yes, Professor.
You know, the powers of this court are expressly stated out on what it should, which decisions rather it should review, being those of the Commission. But you seem to be relying on a quite of several cases that it can obviously exercise implied powers. But in those cases, I've quickly looked at them. I don't see any that supports your argument. Do you have a specific one that authorizes this court to go beyond the statutory jurisdiction?
In the, thank you, Professor Polk. In the ACDP decision, the 2004 one, the issue in there is that there was no commission decision at issue. And the question the court was faced is whether it can correct the administrative error, as it called it, despite the commission, in fact, not making that particular decision. And the answer it gave is that we can, because we are a high court, and as an incidental power of the review power, it extends to legality and ultra various challenges. So we say on ACDP, on a proper reading of it, particularly paragraph 15 of that judgment, that's in fact clear. But the second point is, even if you're not with us on whether it's a commission decision that is a subject of review, the papers make out an application for declaratory relief, and that's where the arguments about 166E of the Constitution, 1721A of the Constitution fall in. Because even if the court might not have powers on the review of the commission decision, it certainly has powers under 172 of the Constitution to declare any law or conduct inconsistent. And that extends to decisions by the CEO, because those are exercises of public powers in the performance of a public function. So you don't escape either way, is the point that we make.
Thank you.
Thank you. I'm indebted to the court.
As the court pleases. My lady, my task is to deal with the merits of our application that is serving before you. And perhaps it is important to start off with making it clear, to the extent that there may be some uncertainty, especially between us and the second respondent, that the dispute that is before the court, it's a dispute between the applicant and the IEC/deputy CEO. That's what this dispute is about. We don't seek any relief against the second respondent. And the second respondent is cited because of the interest that it has in the matter. But they are not the target. We're not criticizing them for what they have done. We are criticizing the DCEO, the Deputy Chief Electoral Officer. That's where our criticism lies. And the criticism is he did not exercise his powers lawfully. That is the criticism. Indeed, the consequence, if we are successful, is if we are upheld on our complaints and on our submissions to you, if we are upheld, the consequence is adverse to the second respondent. But that's all it is. They become collateral damage. The third respondent, I do apologize. Yes, indeed, the third respondent. So the third respondent, we're not fighting with the third respondent. We are questioning the exercise of statutory authority by the first and second respondents.
Also, Mr. Loy, before us, the issue relating to the name and the mark of MK, that is not an issue before us.
I was getting to that. It is one of the things that I want to clear out of the way.
Because that was the decision that was taken initially,
Yes.
And related to the publication of the name, etc., and the mark.
Yes.
And there was no objection to that. That name and that mark was then incorporated into the registration as a political party. But that dispute, because I understood the appeal to the commission to have been on the basis that the mark is confusingly related to us as the ANC, and therefore we object to the registration or the ex post facto.
Yes.
But that is not before us. We don't have to deal with
that.
that.
That is not before you. And to the extent that we've referred to that appeal or the facts of that appeal, it is by background information, because we set out a matrix of what happened and we give you a timeline. It is not the dispute that is before you. It is completely irrelevant.
Whether or not the procedure that was followed, whether that is unlawful and unconstitutional.
Indeed so.
And whether that translates into
Indeed so, Judge Adams.
ultra vires legality issue.
Indeed so. And in fact, that acceptance or that recognition that that appeal is not before you, the fight about that appeal is not before you, dispenses with the third respondent's contentions about preemption, for example. We should not even have to canvass that, because we are not here seeking a review of the Commission's decision on appeal. Never mind that the facts are not pleaded for preemption. There are those problems with it, but it's not an issue that you have to decide. It doesn't enter this equation. Similarly, the first and second respondents raising electoral, they raise it, they're entitled to raise it only if we were here about the dismissal of that appeal, about the decision of the Commission to appeal that decision. Then they would say, in fact, we even have a ready answer for that. They would raise it and we would say, but that's exactly why we are here. If we were here about that appeal, we would say, that's exactly why we are in this court. It's because electoral says that decision stands until it is set aside by court. But it doesn't enter the picture because we are not here about that appeal. And all that is said in the papers about the appeal and the decision of the Commission is irrelevant for purposes of consideration, of determination of why we are here before you, of our application. Now, the facts, in fact, perhaps let me start with what our case is. We say to you, we say that the application before you is about two things that we have pleaded. It is the exercise of the power to approve the registration of the third respondent after the Deputy Chief Executive Officer had made the decision to reject that application. That's the first issue. The second issue that we have pleaded as a complaint for determination is about a defective Section 15.4a notice, where we say it doesn't comply. We don't persist with that leg of the argument, so you will not hear any submissions from us on that. Now, and we set out in our case, we set it out in the founding affidavit at paragraphs, and I'll just mention them for noting because of the constraints of time. We set out at paragraph 11 and 12 of the founding affidavit what it is that brings us here. And then in paragraphs 19, 22, 68, 70, 71, 72, 75, 76, and 77, we set out the facts, the complaints that we are raising, and why we say the decision that the registration is liable to be set aside. It is in those paragraphs. And at paragraph 20, we say there was no new application before the Deputy Chief Executive Officer to decide. And then at paragraph 20, we say insofar as he gave the opportunity to supplement that application that has been rejected, he acted ultra vires powers. Now, the facts, the relevant facts are largely common cause. And it is this. It is on the 4th of August, the application for registration is rejected. And it is rejected, and there's an invitation, an unnecessary invitation, but a helpful invitation, because the IC has to be helpful to applicants for registration. That says nothing precludes you putting in a new application. We say that was unnecessary to say, but in the discharge of a public function to be of assistance to members of the public, they state that. And that's all that it is. That in itself that kind of invitation or assistance, we don't complain about it, that they told them what to do. Now, it is also common cause that there was no new application on the IEC's case and on the third respondent's case. No new application was submitted. I must say, Milady, that in fact, in the answering affidavit, the third respondent initially prevaricates about it. They are firmer in the heads of argument. But in the answering affidavit, they speak of it as whether it's a new application or a supplemented application. They quite noticeably do not commit to what it is that was before, certainly not in the answering affidavit. But they do in the heads of argument, they say, well, we supplemented. So we know there was no new application. We know we know from the IEC that it considered a supplemented application, not a new application. And the supplementation, which is the word that they use, the supplementation is the replacement of signatures that according to the letter of 4 August appear to be fraudulent signatures. And the supplementation that we are told about is they put in a new list of signatures. So that is the supplementing. We say, so before you, what you're required to decide then is whether that so what we do know, perhaps let me finish off the matrix of common cause facts, is that then on the 7th of September, the DCO makes a new decision, and that new decision is now to register, and it is made on the basis of a supplemented application. So the question before you is, the first question would be, was the decision of the DCO to reopen that file, and will make submissions to you that once he's rejected the application, that application is defunct. That file is done and it's closed. And we will show that on the Commission's own papers, they understand the difference between a live application and an application that has been rejected. They understand that. So what they do is, so the first question is the decision of the DCO to consider a rejected application, allow it to be supplemented, and then make a decision on the basis of that application. We say it's not permissible because the decision to reject that application was a final decision. And it is a final decision, but by its nature, however one constructs and interprets the letter of 4 August, it is clear by dictionary meaning, it is clear by context, it is clear by the reasons given for rejection of that application, that it is a final decision to reject an application. But if there was any doubt, it is clear in the advice that is contained in that letter that put in a new application, that the DCO considered himself to have dealt finally with that application.
Ms. Baloy, I'm troubled by the way your client responds to the Commission's version about its intention when it sent the 4th August letter. And perhaps you should look at these paragraphs so that you can assist me. I'm saying I'm troubled by the manner in which your client responds to the Commission's version regarding its intention when it sent the 4th August letter. And I think it would assist if you go to these paragraphs so that you can assist me. Either your client is approbating and reprobating, or there's an ambiguity in its reply. If you look at paragraph 5 of the 45, of the Commission's answering affidavit. Answering affidavit, it says in sending a 4th August letter.
I do apologize.
paragraph 45. Let me wait for you to get there.
Yes.
Are you there?
Yes, I am.
Yeah, it says in sending the 4th August letter, the DCEO did not intend to foreclose the possibility of Umkhonto Wesizwe submitting a supplemented application, right? And your response appears on page 210 of the bundle. It's paragraph 65 of the reply. And there's an admission there that the door was not closed on the MK part to supplement. You see, the allegation you are responding to is that the door was not closed to supplement. And then there's an admission that indeed there's an admission that the door was not closed
Yes.
to supplement.
Yes.
But then you go on and your client says, however, I deny that the commission invited them to submit a supplement.
My lady, what is contained there? It's two things. Your ladyship would note that in our founding affidavit, we do make the point that once the application was rejected, the door was not closed for them to bring in a new application. That we say that. We say, and as a matter of law, they could have submitted a new application. Yes. And that's what the letter of 4 August was conveying to them, bringing a new application. So where we say that we admit that the door was not closed to them, it is simply to that.
But the paragraph under that you are responding to,
Yes.
it relates to the intention not to preclude them from submitting a supplemented, not a fresh application,
Yes.
a supplemented application. And your client's reply there is an admission that the door was not closed.
Yeah. My lady, it depends. One cannot read the replying affidavit divorced from the founding affidavit. In the founding affidavit, our position is unequivocal. And that's where we make the case. That's where we make the case, not in the replying affidavit. We make the case in the founding affidavit and unequivocally say that the door was not closed to them. They could bring in a new application. We say no more than that. Now, here when perhaps it's inelegant drafting, but this paragraph that your ladyship is referring to in the replying affidavit has to be considered with what we say in the founding affidavit. And in the founding affidavit, where we make our case, we say they could have brought in an application. But further on, in that same paragraph 65 that your ladyship is referring to, if we are in any way not clear, because we drafted in the way we did that first sentence, it is clear as we continue that we are disputing an invitation to supplement. So that's what the next sentence communicates. It says, well, there was not even an invitation to supplement. Yes, if the commission had said supplement in its letter, what your ladyship I would expect, what your ladyship would see in that paragraph 65 would be a clear statement of he was not authorized to invite them to supplement. But that's not anything new that arises from the replying affidavit. If you look at our founding affidavit, we do quite clearly say that that they could not supplement. The door was not closed to them to put their name on the ballot by putting in a new application, but they could not supplement. And your ladyship has submitted affidavit, finding affidavit must be read together with this replying affidavit, and that should clear any uncertainty in what we intended to convey in the replying affidavit.
Perhaps before you move on, I've got another question for you. I should raise it now. There's a point your client takes about the lack of a distinguishing mark in the third respondent's application.
The lack of?
A distinguishing mark.
Yes.
In the third respondent's application that was submitted to the commission. The application appears at page 111 and 112 of the bundle. It appears to be a copy. So I just want to clarify, perhaps this question I should leave to the commission and the third that response. Perhaps I should clarify if you are persisting with that point. Are you persisting?
About the absence of a distinguishing mark.
Yeah, in the
No.
application.
No.
You are not persisting
No,
with that
my
point.
lady, it falls under the complaint about the notice that the Section 45
Oh, I see.
notice was
I
non-compliant.
see.
We have
You're not
abandoned
persisting with
that complaint. My lady, so I was at a point where I was saying we look, what the court would have to consider is the decision that was made to register, and then to the nature of the decision of the 4th of August, because the respondents say that's an invitation to supplement. It's not a final decision. So the court has to consider that letter. We have the tools of interpretation apart from the terms of the letter itself. And our submission is the letter unequivocally communicates a rejection and an invitation to reopen the application, to put in a new application. But in fact, I said earlier, my lady, I made the submission that the commission and the CEO, they know the difference. And in their answering affidavits, they know the difference between keeping an application open to allow it to be supplemented and making a decision that rejects an application. The difference is that there is a difference. Before you reject, at least that's what they have done in the past, before they reject, they have given a party the opportunity to supplement. And in fact, what they did in that case, my lady, I just need to find the reference. This is a decision. Yes, this is a decision in an email. If your ladyship would go to page if the court would go to page 121 of the bundle, this is the commission's answering affidavit. And this is from Mushwana Akani, and it is to Mr. Jabulani Khumalo. And this is sent on the 22nd of June, 2023. It says, your application for registration of a political party refers. Please note that the registration is done in accordance with Section 15 of the Electoral Act and as prescribed. Kindly note that in order to meet the requirements, your party must comply, and it is listed, submit a deed of foundation, and then Annexure 2 must reflect only one logo of the party. And the next paragraph is important. It says, we request that you respond by no later than 14 days of this correspondence by sending additional list of supporters required. Please note that your application will not be processed until we have received all outstanding documentation from yourselves. Failure to comply will compel us to reject your application for registration. So what the commission does here, or what Mr. Akani does, is to say to them, your application is still live. We haven't finalized it. It's still live. There are problems with it. Fix those problems. And he prescribes a period. Sensibly, one would say, well, if there is a power to supplement, it could never be a power that is open-ended, or in fact that allows a party to take its time and submit and leave this application hanging in the hands of the IEC. There has to be prescripts. You have to do it within a period. And that's what they do in this letter. They say you have 14 days to comply. If you do not comply within 14 days, we will reject your application. This is what they do on the 22nd of June. The letter of the 4th of August is completely different. It says your application has been rejected. And what that points to is the commission is alert to what is possible to do before you reject an application. And that which they do here is to keep the application live. And they say so in so many words. They say, we will hold it, we will not process it until you have submitted, and if you don't submit, we will reject the application. So the new explanation that, well, this letter of rejection, forget what dictionary meaning of rejection is, forget the context of the letter. In fact, including this history, because this is to the same party. So the history is relevant, the history of how they have dealt with this previously, this same application. They have told them, if you don't do this, we will reject your application. And they proceeded to do that.
Is that similar to giving them an opportunity to supplement?
In this letter, indeed so. We say in this letter they say, we don't have I must say, Judge Chongo, we don't have the full history of this and what is behind it and what was submitted.
Yes, but the content of what you are reading now, they're giving them an opportunity to supplement.
Indeed so.
So the CEO or DCO has some kind of discretion.
Well, Judge Chongo, you would have seen that we say there is no such discretion, but that suggests that him writing in this way suggests that he considers himself to have a discretion to do this. Well, we make the firm submission that any exercise of discretion has to be grounded in the Act itself.
Well, the Act does not, in any case, say that an application cannot be supplemented.
The Act doesn't say that, but the Act is silent, but he is a creature of statute. And what the Act has done is to define his powers. And the power, any discretion that he has to be found in an interpretation of the enabling provisions that, in fact, it's a reasonable interpretation that it includes that he has a discretion to allow supplementing applications. But what we say is, well, even if he does, even if we are wrong in our assertion, that because the Act doesn't prescribe that he's got a discretion to permit supplementing of applications, even if we are wrong with that, the decision of 4 August remains an unlawful decision, because that's not an invitation to supplement. He's made a final decision. He is functus officio with that decision. But effectively what he has done with the reconsideration of the same application is he has gone and revised his earlier decision, because that is the legal consequence of what he's done, especially because he bases his decision on the very application that was rejected. So what he's done is, I think an example would be, maybe practically what would happen is, when an application is rejected in the public sector, is it would be marked rejected. That's one picture that one has in mind. It would be marked rejected and it would be filed away. Even if it's not marked rejected, it would be filed away because it's done, it's finished. There's nothing more to do with that application. Now, to get to a point where he reconsidered that application on the basis that it is supplemented, he has to retrieve that rejected application. He has to retrieve it and then reconsider. So effectively, he sits in a position where he reviews his own decision and reverses it, because that's effectively what he has done. So we say he's not authorized by the Act to do that. That decision was done, that application became defunct. There was no application before him for further consideration. An application would come before him if a new application was filed, as he advised the third respondent to do.
4 August, could you please take me through the last paragraph, first and second respondents answering affidavit?
Professor, you say I should look at the last paragraph.
The last paragraph.
Yes. It's page 44. I do apologize, Justin. It's page 44. Yes, the last paragraph.
Annexure AA7.
Mine is FA4. And it is. Yes. Yes, we attached it as FA4. Yes, that's what I was looking at page 44. Yes, the last paragraph,
Yes.
Professor says, the application, therefore, does not substantially comply with the provisions of Section 16 of the Electoral Commission Act and regulations. And then there's a signature.
I'm more
This
interested
rejection of the application does not debar you from submitting a fresh application.
Yes, I want you to pause there. What does that afresh mean? Doesn't mean you can supplement what you have already submitted, but address the shortfalls that have been identified?
Yes.
Or does it entail completely coming up with a fresh application?
Professor, not to be facetious, I must say that I'm actually even embarrassed to pull it from my file. The dictionary meaning of, Oxford Dictionary meaning of fresh is new. That's what it is.
Totally different from supplement.
Yes. So you cannot supplement. You can't be supplementing if it is a new application. Because what the third respondent, assuming that the third respondent considered, and it must have, because this letter speaks for itself, that the third respondent considered itself to be submitting a new application when they supplement. The debate would be, well, let's look at it. What did you do with it? Right? What did you do? But we know that the letter says, just complete the signatures. Give us that signatures. So there is no new application by any definition. In fact, the third respondent doesn't assert that it submitted a new application. It doesn't. It makes common cause with the IEC that it's supplemented. And we say, but the decision maker said to you putting a new application. Now, what this decision maker then goes on to do is to revise that decision that they made, which is, I want a new application from you. And later on makes, when there's now supplementation, they tell us in their papers, makes the decision, well, that decision that I made is now set aside, because that's really what he did. It's now set aside. I will now consider this old application as supplemented.
Yeah.
And there's no other way of coloring it.
Let us roll the wheels back just a bit. The 1st of June 2023, when an application was made and there was an opportunity to make objections. 9 June again, opportunity to make objections, and nothing occurred. What would have had happened there had the objections been made?
At which point, Professor?
Between 1 June, the first period being the 1st of June 2023, on the first application, wherein the commission, the Deputy Chief Electoral Officer identified some concerns regarding the logos.
Yes.
And your client there had never made any objections.
Yes.
The second period, that is the 9th of June, again, no objection whatsoever forthcoming up until you come back now to the rejection afresh.
Yes. Well, Professor, what we say is that we did not object in the first and second notices is of no consequence to the application that is before you. It is of no consequence whatsoever. It would be of consequence if there had been a new application, as this letter says, of August, if there had been a new application and we did not object. If a new proper application as required by Section 15, which means they would have had to publish the notice, they would have had to submit a new set of documents. By new set of documents, I include that they may well have wanted to run copies of the same old set of documents that are now complete and submit this to the commission. That would be a new application. We would be entitled, if we have good grounds, we would be entitled then to object in that 14 days period. If we did not object, this is a new application, if we did not object, that question would arise. The question would arise for debate, that why are we here if we did not object? We may well have an answer. We may well have had an answer, and the answer would probably have been that, well, that in fact, I think it's in fact, let me take a step back, Professor. I think what we have before you today is a complaint about which we could not object. It was incapable of an objection, if for no other reason, for the reason that it was not published, this application. So we are not hit by the inability to object, because you can only object when you have notice, when you know this is the application, have you identified grounds for objection. So we could not have objected to this application. So the history of not objecting is irrelevant with respect. It's irrelevant because that has nothing to do with the application that is presently, or the complaints that we are raising before you, but it is also irrelevant because the grounds on which we rely, we seek a review of a decision, but that decision is a decision that is made after the expiry of the objection period anyway, by its nature, because the period runs 14 days for objection. The commissioner, the electoral officer doesn't receive an objection. He assesses the application, as in this case, assesses the application and decides it does comply, right? It does comply, and let me register them. Our complaint arises only at that point, how he came to make this decision.
Ms. Baroi, I don't intend to cut you, but I'm very concerned about time.
About time.
You've gone 25 minutes over the allocated time, and we will have to afford the other parties the same benefit, and we will run into difficulties with time because this matter is set down for one day. So I'd like to urge you to conclude your argument by 11:15, and you will come back to reply, so you'll have an opportunity to raise any pressing issues that you needed to raise with us.
Well, my lady, in fact, I think what we're doing, the further submissions that I would make, we fully canvass them in our heads of argument. And the submissions that I'm making are really just to emphasize. We're not bringing any new facts before you or any new argument before you that is not already within our heads of argument. So I'm happy to stand by our heads of argument, but if I could just address the supplementation issue. I'd already touched on it, that our criticism, firstly, you would have to find, to get to the supplementation question, you would have to find that the letter of the 4th of August is an invitation to supplement. You would have to find that, right? So our complaint that he was a functus officio and that it was a final decision doesn't stand if you find that, if you interpret the letter in the way that they want you to do. And then once you've made that decision, then the next question naturally is what we raise, which is, well, does he in fact have the power to do that, to call on them to supplement? If the answer is yes, he does have the power, and which we say he doesn't have the power, the next question would be, well, is what was done supplementing an application, right? So you first have to say that decision is not final. That application was still live, and therefore it is capable of supplementing. The corollary question is, does he have the power to supplement, and where does he draw it from? And we say he doesn't have the discretion to do that. In fact, we raise a concern that any suggestion that he's got a discretion, you would have to say, does he have an unfettered discretion What are the boundaries of this discretion? Because the Act doesn't tell us anything. When can it be exercised? Does he have that discretion? What is the breadth of that discretion? And is that consistent with the provisions that strictly regulate him, what he's permitted and not permitted to do? We raise a concern that if it is suggested that he's got an unfettered discretion, then we enter the realm of arbitrary, unregulated decisions that only the electoral officer knows when and why he exercises it. It cannot be. That is an untenable proposition. Finally, my lady, I need to make the point that the explanation of this letter, it doesn't fall in the mouth of the third respondent to offer any explanation about the interpretation of this letter, because it requires getting into the mind of the author of the letter. We know Godan versus EFF tells us that it is the decision maker that must explain their decision, that provides reasons for their decision. So the third respondent, it doesn't lie in their mouth to explain what this letter means. It's irrelevant that they understood it to mean contrary to what it says on its terms. And we submit that, in fact, it is convenient and opportunistic for them to say, we understood it to mean what the Commission is saying in its affidavit. It is for the Commission to explain the decision. But in fact, in this case, the decision, in fact, the decision to reject but not to reject, to afford the opportunity to supplement and put it in this way, and what was intended with it. In this case, we say it has consequences, that the person that is providing this explanation is not the author of the letter, is not the decision maker. We have Mr. Mamabulo who didn't make the decision. So before you, the court doesn't have an explanation from the decision maker and the author of the letter to speak to this explanation or this interpretation and what is supposed to have gone into the thinking of why I'm giving them the right to supplement and I'm doing it in this way. My lady, those are my submissions. My Leonard Jr. points out, and I will not say much other than to reference it, in the Africa Rise matter at paragraph 15.
Please deal with it in reply. Please deal with it in reply.
Yes. So what it is...
Ms. Baloyi, I'm trying to stop you at this point. Please deal with it in reply.
I'm sorry, my lady.
Yes,
I
please
didn't
deal
understand.
with it in
Yes.
reply.
Well, finally, my lady, we submit that we have made a case for the relief that we seek, which is that the decision, for the reasons that we have stated in our written heads and in these submissions, the decision stands to be reviewed and set aside. That's one. An alternative relief of a declarator, that you must find that the ADCEO acted ultra vires his powers when he gave the authority to supplement. As the court pleases.
Thank you. We are going to take the tea adjournment at this point, Mr. Mutau, for 15 minutes, and then we will hear you when we come back from tea. Thank you. seeking a legality review, right? You're seeking a legality. Am I not audible? The applicant is seeking a legality review, right? A review under the principle of legality. Now, if we are with the applicant in relation to the review relief, that cannot be the end of the matter. We will have to consider a just and equitable remedy. And none of the parties have said anything about that. So, Ms. Baloyi, please think about it. Because we will be left to our own devices if you don't assist us on that point. And then, counsel for the respondents, please touch on the issue when you're arguing.
And, my lady, just immediately on that point, it is also open to the court to do a two-stage process, a la all pay. The court can invite whatever necessary material for purposes of determining a just and equitable remedy, which would of course be fact dependent, etc., etc. And there are no facts that have been canvassed also in the founding papers that required that such a case be met. But that would not be the end of the case. The submission is that it will be open to the court to implement a part 2, as it were, which is just an equity or just an equitable remedy based, and invite the parties to put up whatever material in support of whatever contentions that they may put or contend for. Justices and professors, may I commence by indicating that the fact that I'm wearing sunglasses is not an indication that I take a dim view of the applicant's case, but it is rather a continuation of the difficulties with which I have been faced with in this trip. The struggle of finding clothing and court attire has been conquered, but I'm still trying to locate my glasses, and hopefully we will also come right with that. And against that, may I propose that we structure our address in the following manner. Firstly, we intend to address the material common cause facts and their fatal consequences to the ANC's case. The second issue that we will address is to explain the binding and final nature of the Commission's decision to reject the ANC's appeal and to uphold the Deputy Chief Electoral Officer's decision to register MK as a political party. The third is to analyze the ANC's pleaded case on jurisdiction, and in this regard, we will indicate why it is that there is a new case that is made out in reply. And if I can just foreshadow that part, there is a new case that seeks to rely on Section 21 of the Superior Court Act, which case is not to be found in the founding papers. And the fourth issue we intend to address will be that of condonation and what we say is self-created agency. And lastly, that if we do get there, we will address the merits of the ANC's review application. And the court is alive to the fact that it is this issue which turns on the letter that the Deputy Chief Electoral Officer addressed to MK and how MK understood the letter and the following steps that were taken pursuant thereto. And we will illustrate with reference to authority in the Supreme Court of Appeal why in the exercise of the interpretation of a document, a dictionary meaning is unhelpful. And this we will do with reference to paragraph 50 of the Capitec decision of the Supreme Court of Appeal. And if I may then commence with the first point. We know that it is common cause that the Deputy Chief Electoral Officer on the 7th of September approved the registration of MK as a political party. And this is the decision that we refer to as the first decision. And the ANC says it learned of this decision on or around the 11th of September 2023. And if I can just pause there and indicate that between the 11th and the 20th being the next event, the ANC makes it very clear in its founding papers. It says it could have acted more diligently in ascertaining the contents of the file. And this is very important because it knew that there is a file in which documents that served before the Deputy Chief Electoral Officer would be contained, which would have been instructive of the scope and the breadth of the challenge that it intended to bring. It is not the ANC's pleaded case that the contents of that file were irrelevant because they are bringing a legality challenge. They in fact provide an explanation and they say, well, we could and perhaps even should have been diligent. And they say the reason that they did not do so, and they say they were hoping that the appeal will address all of their issues. And it is important, we submit, to have regard to the nature of the appeal that the ANC then lodged on the 20th of September. And if I can just ask the court to go to Annexure FA6. It is in paragraph 48.
Can you give us the paginated page
It's
number,
page
please?
48, my lady.
48.
If I can start specifically at page 49, the second last paragraph. The ANC writes in its appeal, accordingly, for the reasons set out above, the ANC appeals to the Electoral Commission in terms of section 16(2) and 3 of the Electoral Commission Act to set aside the decision of the Chief Electoral Officer to register Umkhonto weSizwe party as a political party. And we submit that there are 3 observations that should be made from the characterization of this appeal. The first is that the statutory provisions upon which the appeal is lodged, we know section 15 deals with the registration of a political party. Then section 16 deals with the appeal of the Chief Electoral Officer's decision. And in this case, the deputy who was acting on a delegated function. So this appeal is lodged squarely within the premises of the Act. It's a section 15 and a section 16 appeal. It is not a legality argument. And this discipline to remain faithful to the papers is what will illustrate that what we are about now, it is the lawyer's intervention at a later stage to recast the case from what was served before the appeal process, and the outcome that is given relates to that particular process that was given. And perhaps for purposes of completeness, before I go to the second observation, if I can ask the court to turn back to 48. the second unnumbered paragraph, in express terms, the appeal says, Sections 15 and 15A of the Electoral Commission Act empower the Chief Electoral Officer to register political parties subject to certain requirements. So we know this is a dispute about the registration, the decision which was taken to register a political party within the premise of Section 15. And the appeal is then a Section 16 appeal to impugn that decision. Then, if I may proceed to the second observation from the second unnumbered, or yes, the second last paragraph on page 49. The decision was that of impugning or rather the appeal was intended to impugn the decision of the Deputy Chief Electoral Officer, which was the registration of MK as a party. And the third aspect is that the ANC was conscious and alert of the fact that there is a delineation of duties, powers, and functions. And it was quite aware that the next step in challenging the decision of the Deputy Chief Electoral Officer was by way of invoking a statutorily prescribed appeal mechanism, and which is what the ANC did. Because they knew that they could not bypass that jurisdictional demarcation, or the principle of jurisdictional demarcation, by invoking the court's jurisdiction directly. So we are faced with a case where the ANC faithfully followed the architecture and the scheme of the Act. And that discipline that was followed by the ANC yielded an outcome by the Electoral Commission, which outcome was to reject the appeal and to uphold the Deputy Chief Electoral Officer's decision to register MK as a party. And it is this delineation of functions and responsibilities that the ANC appreciated, which we submit cannot be abandoned midstream. It has to be followed through, because as a matter of fact and as a matter of law, having engaged the Electoral Commission's jurisdiction of appeal, or the Commission's appeals jurisdiction, it is not for the ANC to ignore the decision of that process that it followed. It cannot be correct and it cannot be permitted that once faced with that decision, a party would then elect that it is not going to impugn that decision. We know that in administrative law, there is a trite principle that in a multi-decision making process, a party has to target the correct decision. If one were to ask, which decision has direct and external legal effect, which, on the strength of which MK enjoys registration, and on the strength of which the ANC's appeal decision was rejected, it is the decision by the Commission. And we submit that the decision to treat that decision of, or rather the election by the ANC to treat that decision by the Deputy Chief, by the Commission, as if it does not exist, poses for the ANC an irremediable difficulty, or rather an insurmountable hurdle. And it is that palpable infirmity that lies in that case, which we say, for the submission that we're also going to point to with regard to the allocation of duties and responsibilities, that the other interesting topics about the letter and what the letter means and in whose mouth does the definition or the intention lie to clarify, that fascinating as that debate might be, we submit it's a debate for another day. Doesn't pose any controversy here because there is a decision that was taken by the Commission which has direct and external legal effect, which remains valid and binding until it is reviewed and set aside. And it is inexplicable that the ANC then decided not to challenge that decision. And we say what makes it even more inexplicable is if we can just ask the court to turn to the heads of argument of the ANC. In paragraph 18. And the court will recall this submission is made under the rubric of the court's jurisdiction. And in paragraph 18 they say, it is only the chief electoral officer that has the power to register a political party. In the absence of any appeal against his decision, the chief electoral officer's decision to register a political party has direct legal effect and it is final and binding on the Electoral Commission. The chief electoral officer's decision to register the party is to be taken as a decision of the Commission. But we know that on the facts, this is not what we're dealing with. The decision of the chief electoral officer was appealed. And because it was appealed, we're not in the realm of the basis upon which the court's direct jurisdiction bypassing the Electoral Commission's decision is sought to be invoked. And we submit just based on that construction and that argument with which we agree. That we submit should be the end of the matter. The fatal error in then abandoning the decision that it received from an appeal in circumstances where they say on the 11th of September they should have been more diligent by inspecting the contents of the file. Because had they done so, they would have then have established the full ambit of what should be appealed.
So if I understand you correctly, Mr. Mutau, you're saying by impugning that decision, they should have come to the electoral court by way of an appeal.
But targeting the correct decision.
Yes.
Because the facts are, they didn't simply upon receipt of the Deputy Chief Electoral Officer's decision come to this court. They took an extra step of seeking to impugn that decision with reference to the provisions of the Act, 15 and 16. And they got a decision which was unfavorable. So to completely ignore that step in that process is legally impermissible. And these arguments about whether ultra-virus and whether this power can and cannot be exercised, it doesn't arise if an incorrect decision has been attacked. I mean, there are plenty of decisions. We didn't cite them in our heads, but one of them that comes to mind is the decision of SAO. It's paragraphs 41 and 45 of that judgment. I'll ask my learned junior to get me the citation. But it is an uncontroversial proposition that in a multi-stage disciplinary making process, you have to target the right decision. And we do know of the trite principle that even with a remedy of a declarator, it's got to be sought in the right proceedings by the right party at the right time. So you cannot, as it were, simply seek to invoke the jurisdiction of this court because it has a similar status as that of the High Court, when it is not a division of the High Court. And with reference to ACDP, to which I'll return at the moment, the point that is made by the court in that decision is that there is no component of an inherent jurisdiction that is enjoyed by the Electoral Court. So inasmuch as it has the standing of the High Court, it doesn't have that it doesn't have that inherent jurisdiction because it is a creature of statute with reference to Section 20. And if I may, oh, sorry, yes, the citation in Esau. It's Esau and others versus Minister of Cooperative Governance and Traditional Affairs and others, reported in 2021, Volume 3, SA 593 SCA. It's paragraphs 41 and 46. But the principle that the court makes is that trite one. So we know on the facts, when the ANC was faced with the decision of the Deputy Chief Electoral Officer, they didn't say, because it is a legality review, we are going to court. They understood that it is a matter that is appealable in terms of the scheme of the Act. And having followed that, you've got to follow through. You cannot then seek to circumvent the decision that you received through that process that you elected and say, well, because there was no publication, because it's a legality review, it's an invocation of the court's constitutional jurisdiction. Those propositions may be fascinating, but they'll be relevant, we submit, in the right proceedings brought by the right party for the right reasons and seeking the right remedy. And we know then that, perhaps if I can just link this part to the submission that the ANC makes, that it ought to have been diligent by inspecting the file around the 11th of September. We know that it then overlaps with the principle of condonation, because one of the factors that need to be considered is the extent of the delay and the explanation therefore. And thirdly, the question of prospects of success. There is no explanation that is credible, that is put up by the ANC as to why, if its argument was correct that it could invoke this court's jurisdiction immediately upon learning of the Deputy Chief Electoral Officer's decision by the 11th of September, it did not do so. And it only did so, we say, in terms of our calculation, 117 calendar days later. And importantly, there cannot be prospects of success when a party has targeted the wrong decision. And in the absence of prospects of success, we submit the interests of justice as per the decision that we reference in Glenister, the second last paragraph in our heads, that the interests of justice do not favor the grant of condonation in circumstances where there are no prospects of success. And it then takes me to the next point. The ANC then seeks to find refuge in the decision of this court, which was issued at a time when both parties were preparing their papers, which is the Arise Africa matter. And we know there that the delay was about 7 days. And this court expressly says it was a short delay. But secondly, that court was dealing with a matter where its jurisdiction had been properly invoked, which is the opposite of where we are. You have 117 days application which is out of time. There is no explanation, and we submit the question of the opening of floodgates is one that this court should be wary about. Parties should not be encouraged to not act diligently in circumstances where they knew as at the 11th that they could have and should have inspected the file because its contents were relevant to its appeal. So the attempt to recast the case is one that ought not be permitted because it is not in the interest of justice. powers of this court in electoral matters are wide-ranging. Section 18 of the Commissions Act explicitly accords to it the status of the Supreme Court.
The entry
now
is
the
through
High Court.
Section 20.
Whilst there may be
And
merit
here,
in
all
the
the facts are
argument
present
that it does
for
not
the
enjoy
invocation of
those
that
inherent
court's,
powers
jurisdiction.
that the High Court has, it certainly, in my view, enjoys extensive powers in relation to electoral matters. And if I can pause here, what the decision does not say is this. It doesn't say that you are entitled to bypass the invocation of this court's jurisdiction through Section 20, i.e. impugning the Commission's decision. But it says once the court's jurisdiction has been properly invoked, then the powers are wide-ranging. And in paragraph 15 of the judgment, I'm unable to agree with the view that the court, in light of the very wide powers it has in electoral matters, cannot, on application as it is here, correct declared results arising from some underlying administrative error in appropriate circumstances. It would seem to me, by failing to do so, the court would only be acting irresponsibly. So the court would not only be acting irresponsibly, but would be abdicating its constitutional imperative to ensure free and fair elections. So that's the context in ACDP. It is the submission that we made is entirely consistent with what the court finds. Section 20 is the gateway. And reference was made to the principle of when the clock starts ticking. Alan Friend made the submission and said, in respect of delay, the proverbial clock starts at a time when a party ought to have been reasonably aware or have known of the decision. And we know here that the clock on that construction of Alan Friend's submission of when the ANC ought to have reasonably have known of that decision is the 11th of September. And absent an explanation which is cogent, we submit that that is dispositive, or rather it ought to be dispositive of any argument on delay, and it, on that similar basis, impacts on the question of urgency, because this court has a 3-day rule, and it must be viewed in context of the ANC's conscious election to impugn the first decision, but not the second decision. And because on its pleaded case, it says it should have acted more diligently by locating the contents of the file, that is relevant for a second part thereof. The first part is, as at the 11th, they knew of the decision which they seek to impugn here, which they say they didn't need to go to the Election Commission. And of course, the argument has to be, it's a legality review. The Commission's decision, jurisdiction is outstayed, etc., etc. All of those propositions would have been fascinating for us to engage with, but they don't arise because, as a matter of fact and as a matter of law, the Deputy Chief Electoral Officer's decision was appealed, and there is a decision, which is why we are here, i.e., which is why the MK as a political party enjoyed the strength of registration and recognition. And we submit, with respect, that should be, again, the end of the matter. With reference to the Gijima decision, may we ask the court to have regard to the principle in paragraph 66 of Gijima, which is that the illegality, if undisputed and if it is clear, then the court ought to declare it as unlawful. Here, there is no clear and indisputed act of illegality. That issue does not arise. They didn't impugn the correct decision that they ought to have. And the last decision I indicated with reference to caution that was sounded by the Supreme Court of Appeal, with regard to the tendency to use dictionary meanings. If I may just refer the court to paragraph 50. I almost said my junior was sleeping on the job, but he had it. In paragraph 50, the SCA in the Capitec decision, to which I'll give a reference now, it says, Endumeni simply gives expression to the view that the words and concepts used in a contract and their relationship to the external world are not self-defining. The case and its progeny emphasize that the meaning of a contested term of a contract or provision in a statute is properly understood not simply by selecting standard definitions of particular words often taken from dictionaries, but by understanding the words and sentences that comprise the contested term as they fit into the larger structure of the agreement, its context and purpose. Meaning is ultimately the most compelling and coherent account the interpreter can provide, making use of these sources of interpretation. It is not a partial selection of interpretational materials directed at a predetermined result. And before I provide the citation, this point arises in the context where the IEC says, when it wrote the letter, this is what it intended to achieve, and the addressees that not only include the MK, but other political parties understood it that way because it was communication that was directed to them. And those parties reacted in the manner that the letter was intended to be understood by them as the addressees, following which it registered those political parties. There's about 3 or 4 in terms of the examples that you cited. And one can understand that for a party sitting in the position as that of the ANC, to whom the letter was not addressed, that does not have the benefit of context. That does not have the benefit of understanding what was sought to be achieved at the time, can misunderstand the letter by simply looking at the definition of fresh with reference to what the SCA cautioned against, i.e. the dictionary meaning. It is an unhelpful approach. There is no compelling response, and there can never be one, that the ANC can provide, since it was not a participant in that discussion. The ANC cannot second guess what was intended to be conveyed and how it was understood. It is simply not a participant. But we submit this aspect of the case. It is an interesting one to have, but on the facts of this case, we don't get there. We would submit, as I indicated to the court, that I'm going to take less time than was allocated, unless there are issues that the court wishes me to address, and I'll take instructions from my clients and my attorneys to ensure that I've covered all the issues. I'll provide the Capitec citation in a moment. If the court is against us and the court is minded to get past these difficulties and to open the floodgates that a party can ignore a decision that was invoked at its own instance and attack an earlier decision, which is not the decision on which the consequences that it complains of hinges, and the court gets to the question of a just and equitable remedy, we would propose that the court should issue directives inviting the parties to address the question of what would be just and equitable. Because, like in a procurement case, what has been done on the ground in terms of unscrambling the egg would be a relevant consideration. But those issues were not canvassed because, as the court would know, I think mystery is the case in the Constitutional Court that comes to mind, that the question of just and equitable remedy depends on the pleaded facts. And because in the founding affidavit there was no such invitation with reference to the facts as to what should then be a just and equitable outcome, we didn't meet it for this purpose. But it is not, the submission should not be misconstrued to say, I am then saying that the court cannot, in the regulation of its own processes, in terms of Section 173 of the Constitution, direct the parties to file further submissions addressing this particular aspect. If I may then give the court the citation and check. The decision of Capitec Holding Limited and another versus Coral Lagoon Investments 194, Pty Ltd and others is reported in 2021, 3 All SA 647 SCA. And I read paragraph 50 of the judgment to the court. Justices and professors of the court, unless there is anything else that the court wishes me to address.
Questions? Do you have questions? No questions. Thank you, Mr. Mataut.
Thank you. Yes, if I may conclude that the fact that I had indicated that I'm not taking a dim view of the ANC's case is not an invitation for the court not to take a dim view of the ANC's decision, not to challenge the decision of the commission, which was brought about at its instance. Those are submissions.
Thank you.
As the court pleases, if I may just start with a housekeeping issue. We have prepared a bundle of authorities. We beg leave to hand it up. It contains merely some of the cases that we will refer to or that have been referred to, some of the key cases referred to in the heads. Justices and members of the court, like my learned friends, I will address this matter in two broad categories. The preliminary points, of which I will pick 2 or 3, because some of them are really subsidiary to those. And then, of course, the merits. When we get to the merits, I will explain that actually there's one issue, which is the interpretation of the letter. The other issue about the failure to advertise really is another side of the same coin, because obviously if there was going to be a fresh application or a new application, as my learned friends want to categorize it, only then would the duty for another advertising, another gazetting arise. But what I really want to do to this court, members of the court, is to demonstrate that it is impossible, we will never be able to get to the merits of this matter. The problems that the ANC has with regard to the preliminary issues are literally insurmountable. They are insurmountable for the reasons that we have pleaded, but they are also insurmountable for the point that my learned friend Mr. Mutau made, which I will demonstrate actually runs through all the preliminary points. And my intention was to start with jurisdiction, but I want to leave this rhetorical question hanging so that when we get to the other preliminary issues, it must remain at the back of our heads. And it arises from what my learned friend Mr. Mutau has said. We have to ask ourselves two rhetorical questions. One, if the ANC understood, not only understood, but implemented the structure of the Act, that you cannot run straight to court, you have to go via the Commission as the statutory appeal mechanism, which is what they did in relation to the, let's call it the trademarks issue. Then, on what basis is another complaint about registration, the same issue, which simply happens to be on another ground? Suddenly, you have a different approach. You now have to jump straight to court, or you are now allowed to go back to court, or rather to go straight to court. It cannot be. The second rhetorical question, which goes to the root of this, is we must ask ourselves, what would have happened if that appeal had succeeded? We know that it was dismissed. If it had succeeded, I think my learned friends will concede, we would not be here today. So the only reason that we are here is because they failed in that appeal, which was decision given on the 24th of November. But not only did they fail, and this comes to, I want to explain what my learned friend Mr. Mutau says is inexplicable. The failure of the ANC to explain all these delays. And I will demonstrate that it is not inexplicable. It is actually part of what we have characterized as the abuse of the court process. Now, here is a party which has, doesn't matter which term you use, we can call it preemption, can call it acquiescence, can call it estoppel, can call it waiver, can call it election, it doesn't matter. The legal principle is the same. When the ANC, on the 24th of November, was visited with this dismissal, it had an option at that point to come to this court. 30 days. Once it failed to do so, let's say on Christmas Eve, 24th November to the 24th of December, then it had made an election not to challenge the decision of the commission by coming here. The implications of making that election are far-reaching, because it meant that the ANC accepted the dismissal of its case. We all know that's what happens. That's what the doctrine of preemption is. You get an adverse decision, you have two options. You can appeal it, or take it further, or accept it. Their own evidence is that they accepted that decision. They keep on telling, my learned friend, Ms. Baloyi, tells you, go to paragraph 21 of the reply. We make it clear, we are not here to challenge the appeal decision. Please, these parties are confused. They think we're here to challenge that decision. No, we're not here for that. We're here to challenge the decision of the Deputy CEO. This is what they say themselves. Page 205, paragraph 21 of the reply. Now, the implications of making that election go to this mystery of what is called inexplicable. It's not inexplicable. The ANC did indeed accept that outcome. They had reconciled themselves with the idea of Umkhonto weSizwe Party being registered in South Africa. Not without trying, they tried, but they reconciled themselves with that idea. So what changed? The only thing that made them to wake up from their slumber was the announcement on the 16th of December by former President Zuma that he would vote for, or he would vote and campaign for the MK party, which we place, we say that at page 150 of the papers. So it's not inexplicable. It's logical and it's completely inexplicable. What's inexplicable is their refusal and failure to come clean with the court and explain why they waited for so many months. At paragraph 5.19, we say that this application is merely a desperate political reaction to an announcement made by the former president on 16 December that he will neither campaign nor vote for the ANC, but do so for the MK party, the third respondent. It is unconscionable to abuse our court in such a manner. Because there's no other logical explanation for a party that has said, look, we tried, we're not going to appeal, we're not going to take it further. And then suddenly they tell us literal stories about the festive season. No, the reason why we came late was because of the festive season. Please. Which festive season starts on the 7th of September and rolls on for months and months and months, and then you just wake up on the 7th of January. And my learned friend, Mr. Mutau, is also correct that this court really is being asked to do this. It must overlook the acceptance of the decision of the registration of the MK party, and then it must also condone the lateness, which has not been explained by anybody. I don't know what the court is expected to do. It must make up the reasons why people who say that we learned about this on the 11th of September and we acted on it on the 20th. But we are coming to you, court, 4 months later in the following year. But we have no reason to do that except that there was a festive season and all sorts of unintelligible things. The court cannot do such a thing. So let's park that, because that also goes to in a way, touches on the merits. Why do we say that this court cannot reach the merits? There is simply no room to maneuver. Because the jurisdiction of this court, and I'll address the presiding officer's remarks about the legality review, by demonstrating that there's no legality review. This is just a contrived, it's actually a third case now that is being brought. The first case that was brought in the founding affidavit on the basis that there's a reliance on Section 20. When it was clear from the answering affidavits that that will not work, a new case was introduced in reply about Section 21 of the Supreme Court Act. When it became clear that that will not work, a new case has now been brought for the first time in court this morning about legality, Section 172, something you will not see anywhere in these papers. Section 172. So you can't, at best, then the parties should be given an opportunity to deal with this new case, which we heard about this morning, of Section 172. Let me cut it very short. In South African law, there are 3 types of declarators that you can get. The first declarator is in terms of Section 21(1)(c) of the Superior Courts Act. That declarator is intended for situations where you do not seek consequential relief. It's basically, courts always say, well, we're not here to give you legal advice, as to whether is this the law or not the law. But that's the jurisdiction of the court. The problem with that is that it has to be based on a contrived argument that this court is a division of the High Court. It is not. Section 21 deals with the jurisdiction, and the opening words are a division of the High Court will do this, and one of them is a declarator. Now, the mere fact that a court is said to be a court with the same status as the High Court does not mean, A, that it is a division of the High Court. Neither does it mean that you can somewhere bring a matter there. Because if that argument that was put up by my learned friend regarding the specialist courts and so on, well, then they should have brought the matter in the labor court or the tax court or the water court or whatever, because those are specialist courts with the status of the High Court. That's not what is meant by a division of the High Court. That statutory court, which derives its jurisdiction from statute, must itself, qua that court, have jurisdiction before you can come with all these arguments that are interesting about how courts, apply flexibility and what have you. So what have we got here? We have a situation where the Section 21 does not apply. The second category of declarators in South Africa is under Section 38 of the Constitution. Section 38 of the Constitution says that whenever there is an infringement on your rights, you may come to a court, and I'm paraphrasing, and seek relief, including declaratory relief. Then the third category is Section 172, 1A, which is now being smuggled through the back door this morning. But Section 172, 1A does not apply here, because Section 172, 1A says that whenever a court is faced with a constitutional matter, you can have a declarator of invalidity and so on. Again, I'm paraphrasing because of time. It is only if they had pleaded, not even Section 38, Section 172(1)(a), that the question that the presiding judge was asking would arise. Because as we all know, Section 172(1)(b) then says, once you have made that declaration, then you must have just and equitable remedy, which is just and none of all this has ever been pleaded. We hear about it for the first time here this morning. So the jurisdiction regarding the so-called declarator is absent, let alone the jurisdiction of the main prayer. And my lords, my lady, and the members of the court, it is not us who must speculate, or the court for that matter. We say you have no jurisdiction to come here. They, with their eyes wide open, say that, no, you got it wrong. We are there in terms of Section 21 of the Superior Courts Act. They don't say anything about Section 38. They don't say anything about Section 172, except this morning. Can be. We can't litigate like that. But in any event, this is the clearest case, my lady, my lords, and members of the court. We don't need to twist our minds. This is not a situation like those jurisdiction mind twisters in Chirwa, in Kaba, and all those things in terms of the Labor Relations Act. Here, the legislature has been very kind because they've explained the issue of jurisdiction in the clearest of terms. Here it is. Section 20, bracket 1, bracket A of the Act. The Electoral Court may review any decision of the Commission relating to any electoral matter. So to simplify this, let's not quibble about whether this relates to an electoral matter or not. Let's assume that is so without deciding. And we focus on these few words, that the Electoral Court may review any decision of the Commission. Is there a decision of the Commission before this court? No. Absent the statutory boundaries of the jurisdiction of the court, how can this court even reach the merits? Is there a decision of the Commission? No. But what is worse, there was a decision of the Commission on the 24th of November, and that decision was left alone, knowingly. And now, when there's a decision which, on everybody's pleadings, is a decision of the Chief Electoral Officer or his or her deputy, it's common cause. Anybody like me who has ever been employed at a state-owned enterprise will know that there is an accounting officer in terms of the PFMA of such an enterprise, and the IEC has told us that they fall under the PFMA, those delegation of framework authorities is a PFMA thing. And then there's another body, which is normally a board if it's an SOE, called an accounting authority. A decision of the accounting officer cannot be the decision of the accounting authority. The simplest example is Director General and Minister. The Director General of a department is the accounting authority, and there are decisions that are at that level. The Minister is the accounting authority, sometimes there might be some structure depending on the department. But the point of the matter is that an accounting officer has their own responsibilities. They might even be sent to jail for certain transgressions if they don't perform their duties under Section 86 of the PFMA. So what we have here is clearly a decision of the accounting officer. And that distinction is not one that is difficult to make. If you go to Section 6 of the Commissions Act, you'll see it says the commission shall consist of 5 members, one of whom shall be a judge appointed by the president in accordance with the provisions of this section. That's the commission. And then if you go to Section 12, it says as soon as possible after the composition of the commission, so we know what the commission is, and whenever necessary, commission shall appoint suitably qualified and experienced person as chief electoral officer. The chief, subsection 2, the chief electoral officer shall be the head of administration, shall be the accounting officer of the commission, may exercise such powers and perform all such duties and functions as may be entrusted or assigned to him or her by the commission or this act or any other law. Now, as a matter of pure logic, the latter day, another new case that is made in reply is that now the commission is the CEO and the commission are synonymous or something to that effect. I mean, that's just completely out there. And the reason why that cannot be is, again, let's go back to the text. We can take many examples, but let's take, for example, Section 16.3 of the Act, which says the commission, let's take 16.2, sorry, is more convenient. Any party which is aggrieved by a decision of the chief electoral officer, that's the accounting officer, to register or not register a party, may, within 30 days after the party has been notified of the decision, appeal against the decision to the commission in the prescribed manner. Now, on this argument that the two things are synonymous, that would then mean that this decision of the CEO is a decision of the commission which must be appealed to the commission. What is that? It's clear that this is a two-tier system that is designed by the law so that, and this is very important, because these things are not just put here for decoration. There is always an underlying philosophical or legal reason why this is so. Here, the underlying legal and philosophical reason is what we all know as lawyers as the duty to exhaust internal remedies. Or, if you like, the separation of powers. The law, and this has been said so many times in many cases, Batusta, Kumalo, Zondi, and so on. The law, mindful of the fact that there are specialist bodies
Please proceed, Mr.
Okay, thank you, my lady. The law, mindful that there are specialist bodies such as the IEC, prescribes, let's put it that way, prescribes that when a decision is made at the level, let's say, of the accounting officer, you must then refer that decision to the specialists, the commissioners. They look at that decision And once, if you are not happy, even at this second stage, then you go to court. So there's an underlying rationale why the court insists that a decision of the electoral officer within 30 days must be referred to the commission. Of course, we know that after that happens, if you're still not happy, you then go to court. So that's the reason. And that reason cannot be circumvented on top of it by a party that knows that the reason for that and has actually exercised it, as eloquently put by my learned friend, Mr. Mutau. So unless there can be some, and one cannot think of any, a way of going around the fact that this is not a decision, and on this we are all agreed, all sides. This is not a decision of the commission, but a decision of the chief electoral officer, which by the prescription of law needs to travel the road via the commission before it can ever see the light of day before this court. Now, there's an issue, I think His Lordship, Mr. Justice Adams raised this, maybe indirectly. And it is this issue about whether or not the trademarks issue is before us here. Now, that's a very interesting point, because, yeah, and my learned friends were quite correct. That issue is not before this court. But look at this. The issue that is before this court, if you ask that question in the other way, why was it not in that appeal, the Section 16 appeal? The only reason that issue was not before that appeal is because the ANC failed to inspect the documents on their version until the 7th of January of 2024. That's the only reason. Because we have to assume that when they got the decision, and then they were, if at that stage they had done what a normal person should do, there's a decision to register Mkhonto Wesizwe, what? Let's go and inspect the documentation. Then they would have found the letter of the 4th of August. Then that issue would have been formed part of their appeal, and it would have been dismissed or upheld or whatever. Now, they say, no, understatement of the year. The ANC says we could have been more diligent, we accept that. No, you were negligent and you neglected your duty to do what should be done. Regulation 7 of the regulations, members of the Honorable Court, makes it clear. Regulation 7.2 of the regulations says, the register of parties and a copy of every document lodged with the CEO for the purposes of the registration of a party or the renewal of the registration of a party, the changes in registered names, abbreviated names, distinguishing mark, and so on, shall be kept for inspection by the public at the office of the Chief Electoral Officer. And any person may inspect the register, and if requested, a copy of the register to be made available free of charge during office hours. So the regulations have assisted all of us. If I see there's some party called the Sikakane Party or something, then I get worried about it. I must then invoke Regulation 7.2 to go and inspect the documents, and they'll be given to me free of charge. The ANC failed to do this. And without any explanation, tell us that they only did it on the 7th of January. But this court must overlook all these things and give it a hearing.
The ANC didn't raise the issue of the name and the logo. Did I understand you correctly? Because my understanding of the appeal was that they specifically raised that in the letter. I may be misreading.
That they specifically?
They specifically raised these issues.
No. That's exactly what I'm saying. Yeah. I'm saying they only raised the issue of the logo and the trademark in that court.
In the appeal?
In the appeal,
the
yes.
commission to the
yes,
commission.
Yes, the commission. That's what I'm saying. I'm saying they did not raise this complaint here.
Oh, I see.
No, they did not raise in the commission appeal this issue about the fresh letter and what have you. Yes.
Because my understanding is that they say, take out that sequence, that appeal sequence, take it out notionally out of the sequence. Forget about that. We're not interested in that anymore. We're now following a totally different path based on legality and ultra vires. And on the basis of that cause of action, we apply for a review and a setting aside of the...
Yes, but that gets into two cul-de-sacs. The first cul-de-sac is the one that we've just discussed now, that decision is not a decision of the commission. I've addressed that. Yes. But the second cul-de-sac is what my learned friend Mr. Mutau was painfully trying to explain, which is that had they, and this dovetails with the issue of condonation, of course, and urgency and so on, had they done what I've just read out here, which is to find the information, then surely, because remember they say they got legal advice, surely that legal advisor, even if it was a first-year law student, would have said, I've looked at the papers now, there are two issues. One is the logo issue, the second one is this fresh application issue. Yes. And they would have then put it there. The only reason, and my Lord, this is the point I'm making, the only reason that did not happen is because, according to the ANC, they were not aware of the fresh application issue. Now, the first words that my learned friends here said this morning was that the test is what you are aware of or what you ought reasonably to be aware of. We all know that from prescription law, from everything. And I've demonstrated that they ought reasonably to have been aware of this prior to that appeal. So that appeal, it's very convenient to come here and say, no, forget about it. No, can't forget about it. That appeal is crucial. And the fact that it is crucial is not our making. They have put it in the papers because they understand that it is part of the logical sequence of this matter. So let's leave the issue of jurisdiction. There is no possible way around the jurisdiction point. Let's then go to the issue of condonation. I'm sorry. Yes.
I just want to debate your response to my question about the legality review. And you deal with it in the context of your argument around jurisdiction.
Yes.
Right. Now, my understanding of the applicant's case is that they invoke the jurisdiction of this court in terms of Section 20 of the Electoral Act. But, yes, but really their complaint around the decision they're impugning is that decision is unlawful.
Yes.
That's their complaint. Doesn't that characterize the application as a legality review? Their complaint is that the decision is unlawful.
Yes, my lady, it doesn't matter. Firstly, I will, as I've said, that it's not a legality review, but let's say it is. Section 21A, my lady, does not put an adjective. It says this court will review a decision of the commission, whether it's a legality review a Paja review, or this review, or that review.
Okay.
This court
Yes.
will review a decision of the commission. So it does not assist them to characterize it as a legality review. So what?
Okay, so the substance of what I put to Ms. Baloyi
Yes.
is that she seeks review relief, and that cannot be the end of the matter. In the event on the merits, she succeeds. Cannot be the end of the matter.
can't.
There's got to be consequential relief. And
Yeah.
that was the essence of what I put.
That was the answer. That's correct, my lady. You see, that answer, my lady, is opportunistic. Let me explain. Go to the notice of motion. You'll see that the first relief that is sought is to review and set aside the decision.
It's the agency relief. The first
No, well, the first is urgency. I'm just talking about on the merits. The first relief sought is the review, and I've already answered that. That's already they're out. The second relief, which they tried now to sneak into the jurisdiction thing, is then the declarator. But
But I wasn't asking about that. I was
No, no,
simply
no.
dealing with the review issue and the fact that in the event that we are with them, it's not the end of the matter. And they hadn't addressed that second aspect of the relief that follows.
Yes, my lady. No, I agree. So even if they had pleaded Section 172, your ladyship is quite correct. Even if they had pleaded a Section 172 or a Section 1C of the Constitution, a pure legality review, your ladyship is quite correct. If it was a Paja review, for example, that question that your ladyship raises would fall under Section 8 of Paja. Because Section 8 of Paja is a mirror image of Section 172, 1B of the Constitution. Both of them say it's not sufficient, the point your ladyship is making, to review. You must then have relief to set aside. And that relief is discretionary. The first one is not discretionary. That's why Section 172, 1A of the Constitution says the court must declare.
Yeah.
And then it says may.
Yes. But even the setting aside relief should not necessarily be the end of the matter.
Absolutely.
Because when we do set aside a decision, we've got to consider the consequences
Absolutely.
of
The
setting
ladyship
aside
is quite
the
correct.
decision. Yes.
There's still a further question
Yeah.
about remittal, substitution, and all that. The
So
ladyship-
that question does arise in these
Absolutely.
proceedings, Mr.
Absolutely, because your ladyship, because that question, if let's say it was properly pleaded, is a matter that's in the discretion of the court because of the use of the word may, and it has to be addressed by the applicant. Your ladyship is quite correct. But what I'm saying here is that A is not pleaded, B, even if we are generous and say, okay, well, the court can overlook that, as your ladyship puts it, there is nothing before this court.
No, but I'm persuaded by the approach that
Yes.
Mr. Mutau is suggesting, because there's constitutional court precedence about that approach. And it's of proceeding to Part B, in
Yes.
issuing directives for consequential relief to be properly pleaded.
Yes.
Yeah.
Well, my lady, I don't fully agree. Let me explain. Of course, insofar as I'm complaining about non-pleading, then obviously your ladyship is quite correct. We would be entitled to Audi to deal with that issue.
Yes.
But my issue is this, my lady. That kind of relief is not pleaded before you. The relief that is pleaded before you is a relief in terms of Section 21A, which is the review, or alternatively in terms of Section 21 of the Supreme Court Act. Full stop.
That's
If
not
they want to bring a new case, as I say, we all heard about it this morning, under Section 172, 1A and B, then I would agree with your ladyship. Then you'd say, okay, plead that case.
They don't need to specify the provision. They don't need to do so. If they make out a proper case on the papers that the decision of the IEC is unlawful, then this court would be entitled to review that decision and to set it aside. And the court will have to be concerned about the consequences of
Yes.
setting it aside.
Well, my lady, okay. Well, I don't know if they can really do that. If they can say, let's assume they can say it's a legality review, as the ladyship was saying earlier, successfully. All I'm saying is that it's going to run into the same end of the road. That yes, it's a legality review of what? Of a decision of the Deputy Chief Executive. That decision is not reviewable.
And that's
by
a
this court.
jurisdiction point.
No, no. It's now a substance point. I'm saying the decision of the DCEO is not reviewable before this court. And that's what Mr. Mukhale was trying to say in the morning when he talked about immunity. He mischaracterizes our argument to be saying, therefore, that means that a decision of the DCEO is not reviewable, will never be reviewed. I think that's what he said. No. How could we make such a ridiculous submission? Of course, that decision is at a theoretical level reviewable, but you cannot review it directly. It must first be a decision of the Commission. And how does it become a decision of the Commission? By the process of either an appeal or whatever referral. Of course, there's nothing, how can we say the decision is immune? There's no such thing. Even if it was a decision of the person who sweeps the floor, it can be immune from review per se. But the Act has prescribed what kind of decisions should be. It's like, my lady, I say an accident happens in Durban, and somebody brings the case in Cape Town, and then we say, no, this court doesn't have jurisdiction. And they say, oh, well, it means then you can just break my leg and I can never get recourse. No, you are just in the wrong court. You are, the harm that you have suffered is obviously justiciable.
Of course,
but
if this court finds that it lacks jurisdiction over the relief sought, it's the end of the matter.
That's it.
Yeah.
That's the end of it. That's why I was saying, my lady, one cannot conceivably reach the merits. In Makanya, this court said, the SCA, said that one must not mix up the merits of the case. Let's say they have the best, the most brilliant case in the world. One must not mix up that question with the question of jurisdiction. The question of jurisdiction is not whether you're going to win or you're going to lose. It is whether the court has the power to hear you in the first place. And Taba, this court, no, not this court, the Constitutional Court said in Taba, the best way, at paragraph 75, the best way to judge that question is to go to the pleadings. And what do the pleadings say? They are pleadings. They say we're here for a decision of the Deputy Chief Executive Officer. And don't make a mistake, they repeat it in reply in case we didn't hear it the first time. No, we're not here about any decision of the Commission. We're here about a decision of the DCO. To review it, legality, whichever way you look at it, but the one cannot move. Then quickly, let me run to the issue of, the leadership is quite correct, that should be the end of the case. But let's quickly go to condonation and agency. I'll do them interchangeably to save time, but because they are related. But here's the mistake that everybody makes in this court. When we talk about agency here, we're not talking about the kind of Rule 612 agency. We're talking about preordained statutory agency. So it's not something that the court can say, oh, well, okay, someone is going to die, and so on.
Mr. Mpufu, I see that it's 1 o'clock.
Yes.
I'm quite happy to let him finish.
If he's about to finish.
If the court is mindful to take a break, can I just round off this
point, yeah.
This point so that I go to the merits? Yes.
Okay. Okay.
Thank you.
Your suggestion is accepted. Your suggestion is accepted. So you round off the point and then you come back and deal with the merits.
Yes. I want, when the court goes to lunch, to consider this the real scheme of things here. The issue of condonation arises from Rule 6 of the rules of this court. That's the rule that says you have 3 days to bring a review. But the issue of agency arises from the Act. And these two things must not be confused. The agency is at section 20. Sorry. And my submission, of course, is that this party fails on both. But section 20 is another simple, the draftsmanship of this law is encouraging. It says any such review, that was the one we spoke about, of the decision of the Commission, shall be conducted on an urgent basis and be disposed of as expeditiously as possible. Let's forget the dispose of, that's the duty of the court. The first part, any such review shall be conducted on an urgent basis. What does that mean? It means who conducts the litigation is the parties, and who initiates it is the applicant. So if you unpack that, it simply means that by decree of the legislature, not the court, not the people who draft the rules, the applicant must bring the matter on an urgent basis. So you have here a party that has defied not only Rule 6, for which they seek condonation, but they have also defied Section 21B, and they have not asked for any serious consideration of why a peremptory provision of the Act has not been followed, except these stories about festive seasons and so on. So then they have a double whammy, as they say in colloquial language, where they are unable to satisfy the court on condonation for the reasons which I will not repeat of that my learned friend Mr. Mutau, even on the Arise Africa test. Because on the Arise Africa test, you must, firstly, the delay must be reasonable. Here, we have on their version, they say 29 days. We say it's 100 days, doesn't matter. But the point is that it's excessive, even on the AAR test. It's 4 months. Secondly, you must give a full explanation why there was such a delay. Because they are running away from the real reason, which was the press conference of the 16th of December, they are unable to give a full explanation. Thirdly, you must show that there is no prejudice, or at least the balance of prejudice is such that it can be cured by cost. They do no such thing. Fourthly, you have to demonstrate that there are prospects of success. How on earth can there be prospects of success when you are in the wrong court? When you are here to bring a matter that is, let's even not go to the merits, I'll do that after the break. But just within the house of preliminary points, there's no prospects of success at all. So, of course, AAR, this court said in AAR and in Glenister and other cases, that none of these factors on its own is decisive. But it doesn't mean you don't have a duty to address all of them. You have a duty to do so. So the matter A is not urgent. B is the condonation sought can never be granted on any test that is conceivable. And I would rest.
I'd like you to deal with, are you rounding up the agency?
I'm rounding off that point, my lady.
There's an issue they raise about agency, and it's the second leg of the test for agency, that if we don't hear them, they will not have substantive redress in due course. And none of the respondents have dealt with that.
Well, we've certainly dealt with it in the answering of David. I'll give you the reference when we come back. But let me answer it like this. Firstly, as I don't want to repeat myself, that this is not a Rule 612 kind of test. But let's assume it was for a minute. There are two legs, your ladyship is quite correct, of the test for agency. One is agency that is self-created cannot cut it. The second is that the party must show, the point your leadership is raising, that they wouldn't otherwise get redress in due course. On the self-created agency, I've addressed that ad nauseum with all the chronological sequencing that I've done. It's patently clear that the agency is self-created. Now let's come to the relief in due course. Here you have to postulate, my lady. You can't slumber for 6 months and then come to court and say, oh, well, I won't get relief in due course. No. Assume they have done what we have now all agreed they should have done. Assume that on the 7th of September 2023, my lady, when they received the news of the registration of Umkhonto weSizwe, they had done what the Act says they must do and lodged the application, let's say, let's be generous, at the end of September. Then we would have answered and replied, all of us, by end of October. What would have stopped this court from hearing the application in due course? I dare say this court would have sat even before today. So if they had brought the matter as they were duty bound to do, then even the second leg of the agency test, which is the hearing in due course, you can't come here now and say, no, the elections are now next week. Because you have created that situation, and had you acted as you should have, the matter could have been heard in due course. So they fail on both legs, even if you are generous and use the Rule 612 standard, which we shouldn't be using, because this is a statutory agency of a peremptory nature.
So you're saying only the first leg applies in this court?
No.
Is that what you're saying?
No, I'm saying, my lady, I'm saying something different. I'm saying more. I'm saying more than the Rule 612 test should apply here, because we're dealing with statutory agency of a peremptory nature. Unlike the agency that we all deal with in the High Court. But I'm prepared, for the sake of progress, to say, let's even use that lower standard of Rule 612. And I say they fail even that lower standard, let alone the higher standard I'm postulating of a statutory test. They even fail the normal Rule 612 because A, it's self-created, B, the matter could have been heard in due course. So it cannot be condoned because they have not pleaded any condonation grounds. It doesn't fit with the AAR standards. It doesn't fit with Glenister. But at the same time, it is not urgent within the meaning of Section 21B. Those are our submissions on the agency stroke condonation.
We adjourn until 2? Yes. We adjourn for lunch until 2 p.m.
2 p.m. As a courtesy. Now, in other words, our anchor submissions on the preliminary points, which in our respectful submissions are completely insurmountable, is the issue of jurisdiction and then the issue of condonation stroke agency, as we discussed before lunch. Now, to transition to the merits, I'd like to read at page 198 of the papers. Because this is what they say their case is. I was going to start at paragraph 20, but I've already made that point. That's the point about hearing for the first time on 7th of January. Then they said paragraph 21 at the bottom. The ANC, this is now the ANC itself, Mr. Mbalula's affidavit. The ANC is not reviewing the Electoral Commission's decision that it had taken on appeal. The ANC's appeal dealt with the Umkhonto we Sizwe's registration as a political party as a violation of the Electoral Commission Act due to its causing voter confusion. That's Justice Adams's point. And this is the important part. That decision is not being reviewed before this court. This court is called upon to review the decision taken by the Deputy Chief Electoral Officer to register Umkhonto we Sizwe Party on 7 September 2023 in circumstances where there was no proper application before the DCEO. Now, that then takes us to the merits. Assume everything we've said about the preliminary points will be found against us. Now, what have we got really here? Again, it's one of those things. Once you unpack it, you really see there is no case whatsoever. It was one of those situations where we must just do something. Just shoot in the air, maybe some bird will fly, will fall down. The basis, the fulcrum of this entire case on the merits is that the letter at page 44 of the papers of the 4th of August was a letter that was given an instruction, a direction, compulsion, whichever word you can use, for the submission of the so-called fresh application. And I'll come to that just now. Now, Ndumeni tells us that you can't just pick words, one word, fresh, and then another word, rejection. And then you say, there you are, let's go to the dictionary. It doesn't work like that. Statutory interpretation or interpretation of any legal instrument for that matter, including that letter, is according to Ndumeni and the constitutional court cases that followed it, based on three things. Text, context, purpose. That is the magic formula for interpreting legal documents. What does the text say? Then you can deal with dictionaries and what have you and so on. But what is the context and what is the purpose of the instrument? Now, we have one of the strangest phenomena in legal history, where you have two parties to a letter, let's call it like that, or a contract in loose terms, to an agreement that's contained in the letter of the 4th of August. The party that sent the letter and the party that received the letter, both of those parties tell this court what the one party, what we intended to do, that's the IEC, and Umkhonto we Sizwe tells you how we understood the document. So those two parties who are the primary players in this document are ad idem that it does not bring any compulsion for or a non-supplementation clause. A third party somewhere in the street comes and says to the court, no, those two parties, although they are agreed, one says we did not intend to make it a non-supplementation clause. The one that received it says we also did not understand it like that. But some third party walking in the street says, no, they are both wrong. They are both wrong. We have another interpretation of what it is that they were communicating about. Can be. Endumeni tells us that one of the key, at paragraph 18 of the Endumeni case, one of the considerations in interpreting any document is the surrounding circumstances and the history and the author of the document. What it is that, because the test is not subjective, it's objective. The court looks at the instrument, looks at the surrounding circumstances, and it says what is the meaning, yes, not the old test of the intention of the parties. What is the meaning of this document? Now, the IEC tells us this is a standard letter. They attach similar letters. They say, we send these letters. They have never, even when we've sent them to these 4 other parties, they were never intended to be definitive. They were meant exactly for what happened here, to give the other party an opportunity to supplement, among other things. Of course, if the other party decides instead of supplementing, we're going to bring a completely different application, that's also fine.
So
But-
would it be fair? Would it be fair for, an onlooker
Yeah.
to say whether it was supplementary or it was a fresh application or an old one retrieved, there was an application before the CEO?
Yes. Yes, thank you, Justice Shoma. That's the nub of their case. That question, which is central, because they couch their case in those words. In other words, the illegality is the fact that he made a decision when there was no application before him. My Lord, that cannot be. As I say, when the IEC, the author of the letter, says that this was not what my learned friend Ms. Baloyi, a signal of putting that stamp on the letter, on the file, rejected. Let's put it in file number 5 or whatever it is. No. The intention was, among other things, to invite them to cure or remedy the defects. How do we know that? You see, for the ANC to get away with this new meaning, you see the giveaway is in the founding affidavit. You see this thing growing. At some stage they say the IEC recommended a fresh application. Then they realize, no, this is not good enough. Then in another paragraph they say, no, the IEC said they should give a fresh application. And then in another paragraph they say, no, they were directed. So it grows and grows in front of us. But the truth is the first thing, that it was recommended. And you'll find that in their, sorry, .1, that would be on page 23. Thank you. Yes. It says, first, once the deputy CEO rejected the application on 4 August and recommended that the party remedy the defects by submitting a fresh application. The party could not supplement its application to remedy the defects. But the mere word recommended takes away this definitive interpretation that is being sought. And if you jump to the next page, paragraph 71, you'll see another tentative wording. Having refused to, paragraph 71, sorry, having refused to register Umkhonto we party for lack of compliance and having advised that it may submit a fresh application. That's also fine. It may submit a fresh application, it may do other things. But then all of a sudden, look at paragraph 72. It was also legally impermissible for the Deputy CEO to consider the supplemented application when that office had already directed that a fresh application had to be made. Where does that come from? And then at paragraph 76, they say they should file. Now, all of that creativity, to be generous, is because the letter itself is clearly, there is no reading of the letter that makes it this injunction and the law of the 12 tables. Let's look at the letter at paragraph 44. I'm sorry, page 44. Look at how, if there was tentative language, this is it. The reason why the so-called rejection and so on is the signatures and so on. The next paragraph, this is now getting to the meat. It's because the party, that's the MK party, may have contravened the provisions of Regulation 3.1. May have. It may not have. Such contravention may also trigger the effects of Regulation 15, and then that regulation is quoted. So it gets watered down every time you read it. And here's the coup de grace. The application, therefore, does not substantially comply with the provision of Section 15 and so on. And then the applicant does not debar you from submitting a fresh application complying with all the requirements. On any honest, neutral, as Your Lordship Justice Shongwe says, a neutral observer of a reading of this letter, nobody can come with all this bravado that it was now a direction and it was saying you must do this, you should do that. Is you are not debarred from submitting a fresh application. What is the opposite of substantial compliance in law? It's strict compliance. So it says the application therefore does not substantially comply. So already you can use, the standard that is already being used is that of substantial compliance. Why? The IEC has explained. The duty of the IEC is not to do what it is being asked to do here. This is a democracy. Section 19 of the application is that what the ANC wants is for this court to put a banning order on Umkhonto we and stop it from contesting elections, just as it was done to it in 1960. It cannot be. The purpose of the IEC is to permit, as they say in the ACDP case, which also dealt with this issue of strict compliance. The court will remember the other ACDP case, the Concord one, where they had not put their deposit and so on. And the court said, we want a participatory democracy and substantial compliance. If they paid it a week later, so what? Out of the particular date in the larger scheme of things. So that's the spirit within which all these things must be interpreted. In a spirit that promotes democracy, that promotes more participation, that promotes all the values in Section 19. As Section 39(2) of the Constitution says, when we interpret these instruments, we must use the lens of the Bill of Rights. So to now want to change a letter like this in that in the light of that context, that constitutional context, as if the letter was saying, look, if you don't this, you are out, goodbye, and so on, but is really testing the court too much, and the system, quite frankly. So you must now put a gagging order, a banning order, as it were, on a political party and disenfranchise millions of voters simply because the party may have contravened the provisions of Rule 3(1)(a). Really? Now, let's come to the nub of their argument. Fresh. What does fresh mean? So this court is now supposed to say fresh can only mean a new, completely new application forget the context of the letter, forget the normal practice, forget the Constitution. It can only mean that. Well, let's start with the text. The word fresh, even if you go to a dictionary meaning, does not mean these things that we were told here. The Collins Dictionary says, a fresh thing or amount replaces or is added to a previous thing or amount. In other words, it could be a replacement or an addition. And we all know addition, amendment, what have you. It's a fresh, it still qualifies as a fresh. Remember, this is not a statute. For heaven's sake, it's a letter. And the letter, a person chooses a particular word and so on. It's a letter. And the writer of the letter tells us what they were seeking to convey. The recipient of the letter tells us how they received it. The Collins Dictionary goes and says the following: synonyms to fresh. Here are the synonyms to fresh. And we'll start with my learned friend, Ms. Valoi's favorite one, new. But they stop there. They say fresh means new. Let's go home now. No. These are the synonyms to fresh, according to this. Additional, more, new, other, added, further, extra, renewed, and wait for it, supplementary, auxiliary. So even on an ordinary interpretation, taking into account that this is a letter we're talking about, and Justice Strong will raise this point, but the fresh thing, even if you take it for at face value, does it then exclude supplementation? It's clear that it doesn't, because the meaning of that word includes. Yes, I concede, my learned friend, one of the meanings is new. But one of the meanings is also supplementary, which is what was being asked for and what was done. Not just it's not as if the IEC is favoring Umkhonto weSizwe for some reason. This is what they do since 1994 until today. If a party, they give them the letter that says you are not debarred from putting a fresh application and so on, and parties supplement. Those who want supplement, those who want bring a new application. But none of the two things is excluded. Yes, Justice.
The emphasis on this particular letter of the 4th of August 2023, is the purpose of that emphasis to interpret section 15, or what is the point of all of this? And if it is that not the same as asking a witness to say, what do you think of this particular provision?
Absolutely.
And is the emphasis justified by either one of the two parties?
Absolutely. Thank you, my lord. In fact, I was going to come to that because this takes us away, and to be fair to the ANC, it's something that comes out of their heads, the answer to that. I'll find it now. Where they say that I'm sorry, I don't want to patronize the court, but that question is very central, because to the extent that this is an interpretation exercise, and we make this point somewhere in our answering affidavit, Justice Adams, where we say that, remember, the interpretation they are dragging us to is the interpretation of a letter, whereas we should be talking about the interpretation of the legislation, Section 15. And that's fatal to the ANC for two reasons. It's fatal in relation to the jurisdiction point that we spoke about earlier. Because remember, Section 15 says the Deputy CEO must register a party. Shall register a party once it's satisfied and so on. So that's the first problem they have. But the second problem is that I think it's Section 16, which then which uses the word may in relation to a so-called rejection. Yes, Section 16(1). Justice Adams, you see there, the Chief Electoral Officer may not register a party in terms of Section 15A and so on, and then it gives those things. So clearly now we're in the land of discretion when it comes to rejection. Whereas if you juxtapose that with Section 15(1), we're in the land of directory and peremptory language. So this, that question really goes to the heart of this matter, as to what is this so-called illegality that let's assume the jurisdiction point is wrong, and this decision can be reviewed. What is this illegality that the Deputy CEO is supposed to have done? Writing a letter? Or has he strayed anywhere outside of Section 15, the wording of Section 15(1) or Section 16 of the Act? And the IEC makes the point correctly, that this so-called deficiency is not even one of those that are spelled out in Section 16, even under the word may, as the rejection grounds, for lack of a better word. So it becomes a merry-go-round that the Deputy CEO has done that which he or she, well, he in this case, is empowered to do. But in the process of doing that, has written a letter about something which may or may not have and so on, to solicit information. But ultimately, the crunch is on the 7th of September when the decision is made. And that's the decision that's being assailed. There's no debate about that. You can look at both the prayers, prayer 2 and 3, if I'm correct. They both specifically talk about the 7th of September. So it's not about some letter or whatever. But this court is being called upon to review and set aside the decision of the 7th, which is
Registration of the party.
the registration decision, correct.
Because they say that the chief electoral officer registered a party, decided on any given day that they're going to register somebody when there's no application before that.
That's exactly.
It's the point that they make. And so to come back to my question,
Yeah.
in deciding that issue, one needs to look at the wording and the context, and obviously the purpose of Section 15, which says that the chief electoral officer shall, upon application by a party in the prescribed manner, register, etc., etc.
Absolutely.
So the question is simply, has there been compliance, and are the requirements of Section 51 complied with?
Yes.
The ANC says, no, there's no application here before.
Yeah.
And your answer is, so I'm saying, does the letter really require such emphasis is given by the parties?
Justice Adams, you are quite correct. The letter is a red herring. That's our case. But unfortunately, we can't simply make that statement. We have to address it because the case is anchored on this flag of fresh application. Where does that wording come from? It doesn't come from the Act, it comes from the letter. So it is the ANC that has chosen to peg its case on this, some word extracted from some letter, instead of going to the Act, which is what they should do, and say, has there been legal, any illegality as far as the discharge of the duty imposed to the electoral officer in Section 15(1), which is how you are framing it correctly. And the answer to that is that there hasn't been, because the court should not be fastidious about some internal communications or memoranda and so on in between. But the court should concern itself with the legality, if it was a legality review, of the decision. Now, that is why, my Lord, then they are forced to say, no, there's no application before the and quite frankly, that's probably their best attempt. And they use that to give that some respectability. Then they use the functus officio rule. In other words, the argument goes something like this. Once you say in the letter, I've rejected and I want a fresh application, then, as I say, it's gone to file H or whatever it's called, and you are functus. That's the fallacy of the argument. But we all know the functus officio rule is itself not a fixed rule. It has exceptions. One of the exceptions is that the decision must be not final and reversible or revocable, whichever word you use. Now that's the question. It comes to that. Even if you use the letter, was that decision revocable? Obviously it was, because among other things that it was calling for was the supplementation of the information. So even if you used this artificial argument of wanting to say no, there were functus and therefore there's no application in front of them, it doesn't work on the text of the legislation and the proper reading of the letter.
Well, the ANC also says electoral.
Sorry? Oh, no, electoral is a point against them. Electoral is a point against them. Electoral says, my Lord, that in fact, electoral even hits them on the jurisdiction point. I'll explain how. Electoral says a decision such as this one, the registration decision of Umkhonto weSizwe, is in the eyes of the law valid and operational unless what happens, or until, not even unless, until it is set aside by a court of law But here's the catchwords which come from the Mirafong case. You'll find them in Mirafong, you'll find them in Odekral itself, and you'll find them in Kelland. It says, set aside by, in a case brought by the right party in the right proceedings. That's where Odekral stings them. So that decision, if it is brought by the wrong party, in the wrong proceedings, in the wrong court, the decision for the registration of Umkhonto weSizwe stands. So the Odekral point is fatal to the case of the ANC. Because if they can't even pass the first hurdle, and let's assume for argument's sake there was something wrong with the decision. The law, for policy reasons, this comes from the old common law, which says that a decision shall stand until such time that it is set aside. It's an artificial, it's one of these things that we do in law to create certainty. And so it's a fictitious thing. So the law knows that that decision might be wrong. But it says, so that we have certainty and no decisions coming up and down. Today you are on the ballot box, tomorrow you are not in the ballot, and so on. That decision stands, once it is made by an administrator, except if it's fraud and all those things, it will survive and be viewed as valid. So, Odekral, far from being a refuge, is a place they should run away from. The final point I want to make on the merits. Sorry. Yes, okay, I've already made this other point about my learned friend, Ms. Baloyi, said the letter unequivocally communicates a rejection. I've addressed that. It doesn't do any such thing. Now, just to again emphasize a point that I've already made. In the law of contract, we have something called the doctrine of quasi-mutual assent. That doctrine addresses the point I was making earlier about the parties to the contract. So the doctrine, if you simplify it, says the following. If I'm selling this item to my learned friend, Mr. Mutau, and we both, our minds meet that this is what I'm selling to him. But for some reason in the contract, we say, no, I'm selling this. It doesn't matter, because the parties' minds have met on the real item, and therefore that the court will enforce that. So I'm saying by similar logic, and I know we're dealing with the statute and the letter and so on, but by similar logic, once the IEC, with all the constitutional editorial that goes with it, says this is what we intended to do. And once the Umkhonto weSizwe says this is how we received that message and we understood it, it was all about the right to supplement. Then it is not open to the ANC as a third party to say those two parties who are party to the quasi-mutual assent, in quotes, are both wrong. That they're both making a mistake. The only person who knows what was really happening is the ANC. How? If I can just check it now. Sorry if the court will just bear with me. Just want to make sure I'm not leaving. Something on page 92, sorry. Right. This is just really a matter of emphasis. On paragraph 66 of the first and second respondents' affidavit, which really captures 92. I'm sorry, my lady. Page 92. This addresses Justice Adams' issue about the application before, whether there was an application before them. 64, I won't read. Say, 65, we've already covered. 66 says, as further explained above, the 4 August letter did not deprive the Deputy Chief Electoral Officer of his power under Section 15(1) of the Electoral Commission Act to register Mkhonto Wesizwe as a party pursuant to a supplemented application in the prescribed manner and form, which addressed the deficiencies identified on the 4 August letter concerning the signatures. That's the beginning and the end of this case, on the merits at least. As the court pleases. Those are our submissions. We are indebted to the court, and we therefore would implore this court to dismiss this matter, firstly because it is premature, to use legalese, to bring it to this court before it can go to the commission. So it's in the wrong court in that sense. The court lacks jurisdiction. In any event, even if the court did not lack jurisdiction, the condonation of the 3-day rule contained in Rule 6 is at best wishy-washy and does not even approximate to meet the requirements that we have in Clandestine, in Africa Arise, and all the other usual cases, Kijima, and so on. But even if that condonation could somehow be granted, the matter is not urgent in the sense that is envisaged in Section 21B. Because my learned friend says, no, matters of this nature are inherently urgent. That's not what that section says. It says they must bring the matter on an urgent basis. It must be conducted in an urgent basis. In other words, this is not a Rule 612. In fact, it's good for them. They wouldn't have to satisfy this court about all the things we were debating, my lady, about in due course and so on. They would simply say, we've just complied with the statute. You don't have to even go further. But they've failed to do so. And therefore, it's not urgent in the statutory sense. Then we then say that the electoral point we've already exhausted. So we say for those reasons, the matter doesn't go past the first base and doesn't get into the merits. But if the court generously wants to go into the merits, then on a pure interpretation of Section 15(1), read with the letter, read with the context, read with the purpose of what we are trying to do here, then there is no reading of the letter and or Section 15 or Section 16 which makes that letter a decree of some sort, that thou shalt bring a fresh application. There isn't. And absent that, the ANC cannot succeed. And because in doing this, it has abused the process of this court and brought a matter knowingly, because we know by its past conduct that it knows that this matter must first go to the commission, but knowingly and disingenuously not telling us the real reason and the real trigger for the application, and giving us wishy-washy stories about festive season, when the real trigger of this is the fact that there was an announcement made on the 16th of December, which then made them to want to reverse their own acquiescence, peremption, waiver, election, no longer to further pursue the registration, or rather the alleged defects in the registration. A decision had been taken, and that decision is taken by conduct or implied by their act of not pursuing that appeal further, that they had acquiesced or accepted, or the doctrine of election, not election in the sense we're talking about, the doctrine of election applies against them. And that's the point that was made by, that was Mr. Mutau was making, that they are, that failure debars them. For all these reasons, and more, quite frankly, the application is doomed to fail. And there is no further way out. Even, and I say this with due respect, even if the proposal of the presiding officer were to be implemented, which of course we would all comply with, which is to say, okay, you can't bring a new case, and the court is quite correct, you can't bring a new case without allowing the other people to deal with it and so on. And therefore you must deal with the section 172 1B point and give us an opportunity. But with the greatest respect, that will be a further waste of this court's time. Because assume that they do that, assume that we respond to it, assume that we whatever. How on earth is that exercise going to go around the question, is this a decision? Assuming it's the worst decision you've ever seen in your whole life, is this a decision of the Commission as prescribed in the jurisdiction conferring section of the Act? The answer will always be no.
Thank you.
As the court pleases, thank you, my lady. My lady, perhaps the best point to start is where Mr. Mpofu ends, about section 172. We, in our reading and understanding of section 172, it doesn't found a cause of action. Its heading is powers of the court. It says, when I've pleaded my case before you, made out, if you find I've made out a cause of action, a sustainable cause of action, 172 tells you what you do. I've complained about illegality. If I manage to persuade you on the papers that that which we are complaining about is indeed an act of illegality, the question that the court will ask itself is, what do I do with it? Now that I have found this, what do I do? You look to section 172. That's how we understand it. You say, my powers of what I do with that conclusion are contained in section 172. And what 172 enjoins the court, mandates the court to do, is you then make the declaration of illegality. But that's not all you do, as your ladyship indicated. You then the court must then consider what is a just and equitable remedy in the light of this declaration that you are required and obliged by the Constitution to make. We are criticized for not pleading what is just and equitable. My lady, without being flippant about it, we have pleaded the outcome that we want. It's for the respondents to say a just and equitable remedy. If you find that what we've done or what they're complaining about indeed is an illegality, the just and equitable remedy is to do A, B, C, D. But we can only plead what the desired outcome. And the court, in exercise of the power in section 172, because it must consider what is a just and equitable remedy in the circumstances, the court will then invite the parties, afford the parties the opportunity, what do you say we should do? And that is what your ladyship is asking of us. So there is no merit whatsoever in a criticism that says, well, firstly, that says we don't plead what is just an equitable remedy in the should you find for us. But two, it's completely wrong to say, it's legally wrong to say 172, we've created a case. Our case is founded on 172. 172 doesn't do that. My learned friend, if I had done that, my learned friend would have been correct to say, no, but that's not what 172 does. It directs the court what to do. It does no more than that. That's what it does. So, my lady, we do not make our case on the basis of section 172. We make a case on the basis of an illegality. There is conduct which is unlawful. That's a case we have made before you. There is conduct that is unlawful both because, we say because it's not authorized by the Act. And if you agree with us, you will find we are correct. It's unlawful, and then you revert to, you then look to 172. What do you do with that? That's the first. And perhaps while I'm still on that, my lady, we do align ourselves with the proposal from the Commission that the parties should be afforded the opportunity to reflect on what proposal they wish to, submissions they wish to make to the court about that, about what constitutes a just and equitable remedy in the event you find for us. The second issue, my lady, and I don't address this in any particular order, and I will try, my lady, my best not to detain your ladyship or the bench unnecessarily. The second issue that we are criticized about is we prematurely came to the court. We should have started at the Commission. Now, that's a valid criticism only if our course of action and the complaints we raise are determinable by the Commission. Now, we know that the powers / jurisdiction of the Commission is prescribed by the Act. That doesn't include any legality review. And my lady, that would take us to later and the debate there. But we know on this Act for sure that it doesn't include the power to decide and determine illegality reviews. It doesn't. Two, it doesn't include the power to determine a virus dispute. It doesn't. If we had gone to the Commission, the Commission would correctly have said, I don't have the jurisdiction to do this. Go elsewhere. So, and if the court accepts this as legally correct, as a legally correct proposition, then the court must find we came to the correct forum. Mr. Mpofu may well think we should have gone to the High Court, to the Tax Court, to the Labour Court, but certainly not the Commission, because the Commission doesn't have the power to determine a complaint such as that we have raised. Now what follows on that automatically, necessarily, is that those provisions, is a question of condonation, those provisions that deal with when we should seek condonation don't apply. So the 3-day period that is being referred to, that we are told we should have done, and I think in one of the affidavits it said we should have made a submission, a comprehensive submission to the Commission.
On that point, whether or not you prematurely came to this court, couldn't you have come to this court by way of an appeal against the decision of the Commission?
If we came to this court by way of an appeal, we could only be appealing the decision of the acting Deputy Chief Executive Officer. That's the only decision.
No, the decision of the Commission by rejecting the appeal made by the applicant.
Yes. Assuming Judge Chongwe, that we had a good case for an appeal to this court, to come to this court, assuming we had had a good case for rejecting our appeal and we had come here, it would be a different case altogether. It wouldn't be...
Whether or not it's a different case, I don't think it matters.
Yes.
The fact of the matter is that decision, in terms of ordinary stance, now if you are unhappy, you come to the electoral court by way of an appeal.
Yes.
Of which you have to ask for leave to appeal from the chairperson of the court.
Yes.
Now my question is, couldn't you have come by way of an appeal?
Yes. Judge Chongwe, the straightforward answer to the question, and I want to carefully keep the distinction between the appeal and the course of action before you now, and the complaints we are raising. Okay. So I do that, but I answer the direct question that comes from you. Now, the straightforward answer to it is we couldn't have come to you on an appeal of that decision of the Commission. Because what we would have been bringing to you, there are two reasons for it. Well, firstly, what we would have been bringing to you is a rejection of our appeal against the markings and the name, because that's what that appeal was about. It's a completely different case to what we come here with. So we would have been coming to you to complain about the decision in there. But that decision, the appeal is rejected. Our appeal was rejected on the basis that we didn't have standing. And correctly so, because the Act says it is the party that objected that has standing to appeal the decision. We appealed having missed a step. And as the Commission, as the Act says, in fact, as the Act says, the Commission then says, you don't have standing to do that. It's an answer that we would have met here if we had appealed. If we had appealed, in fact, I think that is what would have constituted an abuse of process, where the provisions of the Act are very clear that we should have objected first to gain standing. And we are told, in fact, because that decision, in fact, what it does is it simply refers to the Act. Effectively, it says, but the Act says you have to have objected, and so you can't come. So it was never an avenue open to us, at least not a good faith avenue open to us. But that is if we debate, if the court entertains that because we did not appeal that decision for the reasons that I have provided, we are precluded from challenging, from raising an illegality challenge as we are doing on a completely different course of action. Your Lordship would have to say that when you are precluded to do this, because, as my learned friends say, because you appealed, so you're precluded, and we've addressed that. And our address of it is, we are not precluded. We are not here on that application. So the questions of preemption do not arise. We are here on a different case altogether.
But which case impugns the decision of the CEO
Yes.
of registering
Yes.
the third respondent?
Yes. It does, but our position is more nuanced than, because I think it's to oversimplify our position to say it's simply this. It is you want the decision to be set aside. That's what you're challenging, the registration. It's an oversimplified presentation of a case if one doesn't have regard to what are we saying is objectionable, is the illegality that happened. We say there was no compliance with Section 15. We say that because you had already made a decision to reject an application, so there was no live application before you to reconsider. You don't have the power to reconsider your own decision and reopen it. You don't have the discretion to invite a party to supplement. You don't have that discretion, and so for all of those reasons, your decision is unlawful.
In a nutshell,
the consequence of it.
In a nutshell, you're coming on a different ticket altogether.
We do, but the consequence of it is if we succeed, it will be the deregistration, because these acts that we are complaining about result in a registration. So that it's important that chain is recognized, that we complain about specific conduct, but that conduct that we are complaining about results in a registration. If we are good in our complaints, the grounds that we have raised to complain, if we are good on it, the natural and lawful consequence of it is that decision would be set aside to register. Yes, Professor. Professor, I'm sorry, I beg your pardon, I can't hear properly.
I want to follow up on this point. That your case is the irregularity. But a case has been made here that the Commission adopted a rule of practice where with other parties as well, it does likewise, where there is a defect in the application, then it will advise the applicant to supplement or to add some more documents. Then why is it particular in this case who will take it upon, whilst the other parties that were advised likewise are not before this court or are not of interest in this matter, in order to address the question of irregularity by the Commission? Thank you.
Yes. Professor, we have an answer to that. The answer lies in electoral. The answer is in electoral. Electoral says a decision stands until it is set aside, and it has legal consequence until it is set aside. It can be acted upon. So the parties that are not before the court today, their registration remains in place until somebody undoes it. That is the consequence of electoral. It's no less than that. It is the decision stands, has effect until it is set aside. Now, if we succeed, and I wish to make the submission that the fact that a bad conduct that is not authorized by the law, if you are with us, if you find that this which we say is not authorized by the law, indeed it is not. It's not that it has been done 100 times doesn't turn it into a legally sanctioned proposition. Otherwise, because that has implications for the rule of law. The law prescribes what is to happen, and that the Commission and applicants have been conducting themselves in this way, and they have never been caught out. They've never been caught out. Doesn't make their conduct or the consequence of their conduct lawful, subject to electoral. It remains. It will remain. It will have effect until it is set aside, and that is why we are here. And we are criticized. I think Mr. Mpofu says we rely on electoral, and in fact it is against us. We're not relying on electoral. Electoral is raised by the IEC against us. They say, well, electoral applies. That decision, that appeal decision stands, and so sorry, too bad for you. We say, no, but we are not here, firstly, we are not here on appeal, but even on that appeal. But even if we were here on that decision, on that appeal decision, it would be precisely because of the implications of electoral that we approach the court. We can't ignore the decision. That's what electoral tells us. It says we cannot ignore that decision. It has legal effect, it has practical effect. If you want, the only way of having it, of it being changed, is you approach the court. So if this were that appeal, we would have been doing what electoral implores us to do, instructs us to do. Go to court if you want to change it. But in fact, to our case, it's irrelevant. They raised it, the IEC, and our answer was, but it's irrelevant because we are not here about the appeal. But even if we were here by the appeal, even if we were here about the appeal, we would be doing exactly that which the law says we must do. It says binding on us and to the general public.
Did you address us on why this ground of review that you raise on the merits was not raised in the appeal?
We don't deal with that in the papers, why it was not raised, but it's a pointed criticism, and we do need to deal with it. We say it couldn't be raised in the appeal for the reasons that I've already stated. It couldn't be raised because the Commission doesn't have the power to determine. What the Commission has is the power to consider an appeal from a party that objected. And it's about it has the power, yes, to consider an appeal from a party that objected. And it's about the registration of a party. It's a party that objected, it's a party that was not registered, that is complaining about that. Then they can go on to the appeal. We are not doing any of that. And if we had done that or sought to do that before the commission, it would be a complete answer for the commission to say, but I don't have the power. I don't have the power to make determinations about illegality and make declarations, because that's what we are seeking. As a matter of law, it is not a court of law. It cannot make declarations, and it cannot give us a remedy. If I think it's easy to imagine a scenario where the commission assumes it has, for purpose of that kind of application, it says, well, I will assume that I have the power to decide this application, to determine the issues raised. I find that there was an illegality, it was unlawful.
Yes, but your case is that there was no proper application.
I beg your pardon, Malady?
Your case is that there was no proper application before the DCO, right?
Yes.
You could have raised that ground of appeal there.
Yes, the practical reason that we couldn't have raised it there is we didn't know at the time of the appeal. And the reason we didn't know, this which we are complaining about, the reason that we didn't know, and the court must have, with respect, should have regard to that. The reason we didn't know is because what gets published by the IEC by dint of the legislation is the decision to register.
Yes.
That gets published.
Yes.
That the application was rejected and the reasons for rejecting it are not published. It's not matter that is in the public domain. So you have to, and perhaps in another debate, it may well be said, well, perhaps that speaks to a lacuna in the Act. It should be made to publish more than it is doing. But as matters stand, as at the date of our appeal, and as at today, there is no requirement for the IEC to publish a rejection in the Act. There is no requirement to publish their reasons for a rejection. There isn't. We don't.
But you found out about you didn't find out about the rejection. You found out about the decision to register, right?
Because it was published.
On the 11th of September.
Yes, because it was published. So what we do know as facts at the time is there was a first application which had the 2 markings. And then we do know there was a second application which is with a single marking. We then come to know on the 11th of September that there is an approval, there is registration. We know that. And we working on the basis of that second publication. That's why we raised the first and the second. That's why we raised the markings issue. We think that's all there is to it. So our appeal is that which is on the basis of that which is in the public domain, which is the markings issue and the name of the organization. And those are grounds for appeal, and it could only ever be that, because that's all that we know at that point. We couldn't have gone behind that at that point on any other basis until we have information of the IEC, which is in the possession of the IEC. In this case, for the first time, we find out, oh, there was a rejection. That's when we find out. For the first time in January, there was a rejection. And for the first time in January, we find out what were the reasons. We find out the reasons for the rejection. And we couldn't have acted, firstly, we couldn't have included that in the grounds of appeal for the reasons that I've said, the law reasons that I've said, but also temporally in the sense of, well, we find out only in January after our appeal has gone in. So even as a practical consideration, we couldn't have raised this in the appeal. But what we do, in fact, is as soon as we become aware of it, we make the determination. We can't go to the commission, or we make the determination not to go to the commission, and we say, well, the Act doesn't provide for this before the commission. You could only do it in a court. And that's why we come to you, and we come to you in the shortest possible time after we found out this. Now, we've been criticized that, and perhaps we set ourselves up in our founding affidavit, we get criticized that we should have requested documents earlier. Had we requested documents earlier, we would have known earlier. of course, if we had requested documents, but that cannot be used to penalize us because there is no requirement that says I must ask for documents. When a party has been registered, I must ask for documents and I must ask for documents within a certain period. There isn't.
It's in your own interest.
Of course, you would have to do that because you suspect. You would have to, firstly, one would have to go into the mind of, well, surely we don't want to burden the IEC, just practically. We don't want to burden the IEC with every party writing to them and saying, I want documents. So we have to take a sensible and practical approach to this criticism. And it is, our submission is, well, the sensible thing is we appealed because a decision has been made. But what we show very clearly in January is, had we known earlier that this has been done, there is this unlawfulness in this decision, of course we would have come. We would have come to court. And in fact, the fact that we appealed in itself deals with, answers fully any criticism, or rather the invoking of preemption, that, well, we clearly made it very clear that we're not happy with the decision. We are not prepared to sit with it. And we put in an appeal, in a bad appeal because we hadn't objected. Decision was made. We set out in our affidavit that once that decision was out, we started talking to our legal people. We requested documents, we received documents, and we came to court we came to court soonest in January.
Can I just ask you this? How do you view the second decision, which is in fact the decision by the Commission itself? Because that is not being challenged any further. There's no appeal against that decision. But the effect of that decision is, in fact, to confirm the registration of MK.
Yes.
Now, if you're successful with this application, the effect is then that that the registration is cancelled, it's set aside, which would then, in effect, have the effect that it also cancels the second decision by the Commission. Is that how you view it, or will that decision stand indefinitely until set aside by another court? How do you visualize that panning out in the bigger scheme of things?
Well, what the Commission says in its decision on appeal is, and correctly, with respect we submit, is to say that decision of the DCO stands. So what stands is not the decision of the Commission. It is the decision as with when we come to court here and in an appeal court. It is when and you're not successful. It is the lower court's decision that stands. That's that court. So that same principle applies here. Yes. This is, in fact, this is the decision. Yes, the decision is rather, the reference that I'm pointed to is at page 59 of the bundle at 10. The Commission says on these two bases, the one is we don't have standing. I think there's another one that says the decision of the Chief Executive Officer is upheld. So what happens is that decision becomes the operating decision. And so if we are successful, it is that decision that you're setting aside.
The real difficulty that you're facing is that the Act makes provision for an internal dispute resolution mechanism, and you are inviting us to give an order that undermines that internal dispute resolution mechanism. I understand your difficulties, but I don't see how you come up, how you overcome this hurdle. You are not impugning the constitutionality of the Electoral Act, right? It makes provision for an internal dispute resolution mechanism in very clear terms, and you are asking us to allow you to undermine that process and come to your rescue.
Milady,
We can't do that, can we?
I beg your pardon, Milady. Milady, the dispute, the internal dispute resolution mechanisms that are in place, they tell us what disputes get resolved internally through this mechanism. The Act tells us that. What are they? So that is the question. It's not sufficient to simply say for our opponents to say that there are internal dispute resolution mechanism. That's where you go. The question is, what is the dispute? Is the dispute that I raise a dispute regulated by the internal dispute resolution mechanism? It's similar to, Milady, we know the Labor Relations Act sets out your dispute resolution mechanisms of labor disputes, and it sets up the CCMA. But it also tells you the disputes that go to the CCMA, and these are disputes about fair labor practices, dismissals, and discipline, and. And if your dispute is not one of those, and an easy example is, if it's a dispute about my employment contract, it's not a fairness dispute, it's not a procedural, it's not a substantive fairness dispute, but it's a dispute that implicates my employment contract, and we are fighting about the meaning of a clause in the contract. That dispute doesn't fall under the internal dispute resolution mechanisms that have been provided by the LRA. It doesn't. So always when we look at what can we take to an internal body, to an internal tribunal, or subject to an internal dispute mechanism, you look at the nature of the dispute, because not all disputes get resolved there. So the
Which provision excludes this dispute that you are raising here?
Well, it doesn't exclude it because it doesn't say you cannot. What the Act does, it tells you what disputes go to the Commission. It does.
Which section? Section?
Yes, if you look at 16. If your ladyship would bring it. My lady, at 16.1, and there's Mr. Mpofu made a submission that I will briefly respond to. At 16.1, it says the Chief Electoral Officer may not register a party in terms of this section, and then it prescribes there. And then it says at 2B, at 2A, it says an applicant who is aggrieved by a decision of the Chief Electoral Officer not to register that party may, within 30 days after the party has been notified of the decision, appeal the decision to the Commission in the prescribed manner. So unless we can locate our dispute within the prescripts of the Act, so it doesn't go to the Commission because this Act is silent about it. That's not how you define what goes to the Commission. You look at the Act because the Act tells you positively what is it that the Commission has the power and jurisdiction over, and it prescribes that. My lady, there's this question of the
We knew it. It's the case.
My lady, more like that. My lady, there's the Judge Adams asked about the letter, the significance of the letter. Indeed, this case is about interpreting an interpretation of Section 15, whether it permits what was done here. That's what this case is about. The letter is no more than evidence of what was done. It's no more than that. Because without this letter, we don't know what was done. We don't know that there was a rejection of an application. We don't know that there was a decision that they must submit a new application. So it's no more than that. And the debate about its meaning is about whether, it's really a debate about, are we correct that this is evidence of what we assert it is? So it's no higher than that. But the more important point about this letter that Mr. Mpofu, the submissions that Mr. Mpofu makes is, well, the parties understood. Well, he starts off by saying interpretation is an objective process. We agree with that. There's no disagreeing with that, because that's a correct position of law. And then he says, well, but the parties knew and understood what it was, and he invokes the principle that applies in contracts. But that's exactly to introduce subjectivity. Because now you go into the minds of the parties. You say, what were they intending to do? Because that's the question. It's exactly that. It is, now we are being invited, or the court is being invited, to look at what was the author of the letter doing with this. And and when the third respondent, when they received the letter, what was their understanding of the letter? And the proposition suggests, never mind the letter, an objective, never mind what you come out with on an objective consideration of the letter. Consider what the parties had in mind. That is quintessentially a subjective approach to interpretation. And
the point is that sometimes interpreting an instrument, like in the context of a contract, you will look at the conduct of the parties subsequent to their agreement or that instrument having been concluded.
Yes.
And I think that is the point that you're making, Ms. Paloi.
Yes.
That letter represents the conduct of the parties
Yes.
in their understanding of Section 15 and
Yes.
how it was implemented by the IAC.
Yes. In fact, Judge Adams, when you look at the conduct of the parties, it is when you're establishing what in fact is the contract between the parties. So you take their conduct into account together with what they have written. If the parties conduct themselves differently from what is contained in the letter, in the contract, indeed, you would come out at, yes, the contract between the party is manifested by the conduct, by the contract between them. And usually those disputes, and almost in every case, those disputes arise when parties to the contract contend for different interpretations, opposing interpretations of the conduct. And that's when you would say, well, let's look at their conduct as well. And if this is how they've been conducting themselves, then that is the contract between them. Yes. My junior refers me to Komwenzi Security Services. It's a decision of the SCA in 2012, and it speaks to referencing the conduct of the parties at paragraph 15, and I'll just read the last part of it. This follows, there's a dispute between the parties and about the meaning of the words that they have used and the selection of the appropriate meaning from among those postulated by the parties. And the court says, of course you look into conduct, but this does not mean that if the parties have implemented the agreement in a manner that is inconsistent with the possible meaning of the language used, the court can use their conduct to give that language an otherwise impermissible meaning. So it does attenuate my very broad submission of course, that's the end of the matter, you look at their conduct. But if looking at their conduct amounts to an impermissible meaning, then you cannot give effect to that.
and then you just ignore the conduct. If they conducted themselves in a manner that's completely at variance with Section 15.1, then let's just ignore the conduct, because that's what that authority
Yes,
is.
that's what the SCA has said.
Yes,
And that's what we are saying, that they may well have conducted themselves this way,
Yes.
but it does not validate what they have done. It does not make it lawful. It remains unlawful for non-compliance with Section 15. My lady, there's also the submission. In fact, it's in the affidavit of the IEC that and it's about this. It's about supplementing, and the sum of it is it wouldn't have made a difference whether they submitted a new application or they merely supplemented. Because the consequence would have been the same. Suffice only to say that the no difference rule is not part of our law. The courts have spoken about that, and you've got Psychological Society, this is Twelani that speaks to that. So the no difference defense doesn't hold. It's irrelevant that it would have made a difference. It may well make a difference, have made a difference. The court will bear with me. I'm trying to reduce my list of reply. Yes, it is contended that in the replying affidavit, we make a new case. We've pleaded a new case. That's not so, Malay. The criticism arises because in the replying affidavit we reference the power of the High Court to declare, to give declaratory relief. But that's not to make a new case. We have pleaded in the founding affidavit why we say the court has the power to declare. And all we do in the reply with a reference to Section 21 is, well, even this gives you the power. It's really just another building block. Our case is this court does have the power to grant declaratory relief. About the discretion to depart from the requirements or the prescriptions of Section 55, of Section 15 rather. My lady, I just want to refer your ladyship to the Africa Rise matter, and this is at paragraph 13, and what it speaks to family is that in exercising the power in Section 15, the Chief Electoral Officer has no discretion. It doesn't. And this your ladyship will find at paragraph 13 rather, not 15, at paragraph 13.
Paragraph 13 of which case?
This is Africa Rise. It is Arise Africa, Arise, AAAR, versus Electoral Commission, and it is a judgment of this court. It was heard in November 2023, and then judgment is on 16 January 2024. So it's a very recent judgment. Mr. Mpofu helpfully points out, Judge Shongwe, it is in the bundle, in the second respondent's bundle, in the index it's item 4 from pages 130 to 145. We say that deals with any claim for a discretion. My lady, I think I am at the end of my submissions. If you would bear with me that I make sure that I haven't left anything out. Lastly, my lady, we made the submission that even if, because our case is there was no application to consider, that's our case. But if you find that there was an application because they are allowed to supplement, well, firstly you would have to say that that there's a discretion to invite supplementing, because we know the case of the IEC is they exercise a discretion to invite supplementing. So you would have to say there is a discretion to supplement. That discretion was exercised, was properly exercised. We say that application, we would still contend on this submission that, well, that application was closed and done. They call them to supplement it. We say, well, it still didn't comply because there was no Section 45A, 5A notice. There was Section 15. Yes, it's been a long day, my lady. So there was no notice, and that application simply didn't meet the requirements of Section 15 in the application and should not have been granted. My lady, those are our submissions as a court basis.
Shall we close?
I'm done.
Huh? Anything from you? You don't. Done. We've come to the end of today's proceedings. There are no further questions from the bench. I'd like to, on behalf of this bench, thank all the legal representatives for the parties for their assistance. We are reserving judgment, and through the registrar of the electoral court, your attorneys will be notified when judgment will be delivered and the mode of delivery.
We're also indebted to the court on behalf of my colleagues.
Okay.